Okay, perfect. Good morning. So let's start with this first panel. But first of all, I would like to thank again Professor Mocella and my colleagues, the Mercatorum University and the colleagues of the Scientific Committee and Organizing Committee for the organization of this event. Yesterday, thanks to the 4 keynote speakers, we had a broad view of the due diligence systems in a hard law approach, but also in a CSR, in a corporate social responsibility approach and voluntary approach. And its significance and its impact on labor law, not least in the light of different national experiences. The analysis continues today, on the one hand, by examining other systems, not just in European Union state members, and on the other hand, by having a deeper vision of the different problems and of the due diligence. And so I have read the various abstracts and found their approach on the due diligence really interesting. So I shall begin straight away, not least to keep the schedule, by giving the floor to Professor Papadopoulos. He's an expert in company law. He's an associate professor at the Cyprus University, and he's joining us in a remote modality participation. Thank you, Professor. You have the floor.
Thank you so much for your acceptance of my paper. I'm delighted to give a presentation in your conference. Unfortunately, it will be online, although I would prefer to be physically there, maybe in future. But at least technology allows us to give this presentation. Just to share my screen. The topic of my presentation is director's duties and corporate sustainability due diligence in Cyprus company law, modernizing fiduciary duties under common law. I'm sorry? Okay. I thought something was wrong from technical point of view. You can let me know. So a very short introduction to Cyprus company law. Cyprus is a mixed legal system where company law is based on English common law, and the Cyprus companies law is based on old English company law, which is Companies Act of 1948. It's a translation from English to Greek. This is due to the colonial past of the island. After independence of the island from the British rule in 1960, it was left to courts of justice in a rather bizarre fashion to clarify inter alia the relationship of Cypriot law with English common law. And the Cyprus courts decided that common law is binding. Then the legislature adopted a special law that made English common law and law of equity binding for Cyprus courts. And the Cyprus companies law constitutes an open-ended code, which means that it continues to be interpreted in the light of English company law. Cyprus is small in territorial size and population. It is just 1 million residents, but it hosts registered offices of many companies of international significance. For example, eToro, Wargaming, before acquisition, Rakuten, Viber. And it is a financial hub. It is an international business hub, profiting from its geographical position close to Europe, Asia, Africa. Following the 2004 accession to the EU, Cyprus is not anymore offshore financial center, but of course it preserves the mentality of attracting foreign investments. Cyprus used to have the lowest tax in EU. It's 12.5%. Now it's not. There are some other countries like Bulgaria and Cyprus with lower taxes. And Cyprus is a popular destination for capital coming from former USSR countries, but of course not only, lately also from Middle Eastern countries and also from some African countries. And there are many venture capital taking place in Cyprus. Now, the director's duties, unlike UK Companies Act of 2006, director's duties are not codified into Cyprus Companies Law and are based on English common law. Until 2006, in English common law, the director's duties were based on common law, on case law. They were not codified. In 2006, the UK Companies Act 2006 codified them into the text of the law. Cyprus did not follow this approach and continues to have director's duties on the basis of common law. Hence, corporate sustainability due diligence requirements under the implementation of Directive 2024/1760 into Cyprus law fall within the scope of common law fiduciary duties, and more specifically within the scope of the duty to act bona fide in the interest of the company. This latter duty is interpreted strictly under Old English case law and does not adopt the wider approach of the principle of enlightened shareholder value, the modern approach, of Section 172 of the UK Companies Act, which codifies the latter common law director's duty. So the previous common law director's duty was more restricted. The codified version of it is wider. According to the common law fiduciary duty to act bona fide in the interest of the company, a director must conduct business affairs of a company for the benefit of the company as a whole and not for some other collateral purpose. In this framework, there is a quite limited possibility for a director to consider corporate sustainability and ESG in general, unfortunately. So Old English common law specifying towards whom directors owe their duties still apply to Cyprus company law. Now, with regarding modernization of fiduciary duties, as Cyprus Companies Law does not have a similar provision to Section 172 of the UK Companies Act, the modern duty to act for bona fide, when directors of Cyprus companies comply with the duty to act bona fide in the interest of the company, they are not obliged to take into account the factors of Section 172, such as the likely consequences of any decision in the long term, the interests of the company's employees, the need to foster the company's business relationships with suppliers, customers, and others, the impact of the company's operations on the community and the environment, and the desirability of the company maintaining a reputation for high standards of business conduct. An overview of Section 172. Nevertheless, the implementation of the CSRD directive would impose certain corporate sustainability due diligence requirements on Cyprus companies. This means that the duty to act bona fide in the interest of the company should incorporate such currently absent corporate sustainability due diligence requirements. So these absent corporate sustainability due diligence requirements must be incorporated into the old version of the common law duty to act bona fide. This presentation argues that despite the lack of codification, the common law duty to act bona fide in the interest of the company should be widened and modernized in order to comply with the corporate sustainability due diligence requirements of Directive 2024/1760. Although Cyprus Companies Law follows UK Companies Act 1948 and not UK Companies Act 2006, the evolution and interpretation of Section 172 of the UK Companies Act could offer useful guidance towards the widening and the modernization of the common law duty to act bona fide in the interest of the company. So Cyprus law could learn a lot from the modern version of the codified version of bona fide director's duty. And of course, this could be incorporated into the old version of the common law duty. Now, very briefly, the common law duty to act bona fide in the interest of the company, a director must conduct the business affairs of a company for the benefit of the company as a whole and not for some other collateral purpose. This was declared by the famous Smith versus Fawcett case, the British case. The test to determine whether a director acted in breach of the bona fide duty is a subjective one. That is, the court must consider whether the director considered that she was acting for the benefit of the company as a whole. It is a case of extra-sure travel, insurances versus Cattergood. The test is subjective and may even be passed where the court considers the actions of a director to have been unreasonable. That is, providing the court is of the option that the director honestly believed that he was acting in the company's best interest. So there is a high level of subjective nature. The issue is, therefore, one that is concerned with the director's state of mind. Accordingly, in the majority of cases, the subjective nature of this test will favor the director, and it will be difficult to establish a breach of this duty, as it was declared in the Recenti versus Cohen case. However, there may be cases in which it is patently obvious that the director's intention could not have been to benefit the company as a whole. And here we have the characteristic example in the Roith case, where we had a breach of bona fide duty. There was a director who was very ill. He entered into a new service agreement with the company. He agreed to this for himself. And this agreement included a provision of generous pension to be paid to his widow in the event of his death. So he knew that he was sick, that he was about to die after a short period. So he made this new contract and he secured a high pension for his widow, future widow. He failed to disclose his poor health and he died shortly after. His widow claimed that the benefit of the pension and, of course, the deceased director's service agreement had been entered into with the object of enabling his wife to make a claim in excess of an amount that might otherwise have been considered appropriate. And the court held that the director had acted contrary to the interests of the company as a whole. The director's sole intention was to benefit his wife without consideration for the interests of the company. And now, the duty to promote the success of the company, the modern duty of Article Section 172 of UK Companies Act, this stems from the equitable principle that directors must act bona fide in what they consider to be the best interest of the company as a whole. Section 172 provides that a director of a company must act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. The duty is subjective. The question is whether the directors honestly believed that their act or omission was in the best interest of the company at the time the decision was made. The court will not seek to make its own commercial judgment, but would consider all the evidence to determine what the directors believed. Of course, here we have Article Section 172, which lists various matters. Whether directors should consider wider constituencies or stakeholders than the company and its shareholders in managing the company has long been a question for discussion by commentators. So here we have this long list. We have the long-term consequences, the employees' interests, the development of business relationships with suppliers, customers, and others, the community dimension, the local communities, the environmental protection, of course, the reputation for the high standards of business conduct, and the need to act fairly as between members of the company, fair trade. The section makes it clear that directors must act not only in the interest of the company as a separate entity, but must consider also the benefit of its members as a body. Furthermore, the list above is intended to ensure that the interests of other factors are taken into account as well as the board's decision-making. So ESG requirements could be incorporated here. Section 172 replaces the old version of the UK Companies Act, Section 309, which provided that the directors must have regard to the interests of the company's employees in general, as well as the interests of the members. So the previous provision, the predecessor of Section 172, was very, very narrow and short provision. The previous common law rule in Percival versus Wright with regard to a duty being owed to the providers of capital had previously been extended by statute to include the interest of employees by the Companies Act 1980. This was then consolidated in the Companies Act of 1985, Section 309. Previously, it was inappropriate for directors to take account of the interests of employees. It was a very strange approach that we had the example of Park versus Daily News, that the directors could not consider only the interests of employees, the interests of employees in comparison, in connection with the shareholders' interests, which was very difficult. Whether single shareholder succeeded in obtaining an injunction to restrain directors from making payments to employees in excess of their legal entitlements where a business was ceasing to exist. So here in Park, the directors decided to give an extra compensation to the employees, and this was found to be to the detriment of the company and the shareholders' interests. Since the introduction of the new duty in the 80s, there have been few examples of the extended duty. In Saul case, the directors justified their decision to carry on running the company inter alia in terms of protecting the interests of employees. This was therefore regarded by the judge as appropriate. Creditors, of course, must be taken into account, but as the position of employees, only to the extent that the interests of shareholders are promoted. Directors do not owe duties to the company's creditors, but if a company is insolvent, it has held that directors must have regard to the interests of creditors. We have various cases here. Now, let's move into the end of the closer to the end of the presentation. The enlightened shareholder value, which is something that Cyprus should adopt, should interpret the common law duty in the light of enlightened shareholder value, despite the fact that there is no legislative provision. The interests of the shareholders as a whole are the paramount consideration of the directors. This is captured in section 172, which requires directors to act in the way they consider to be most likely to promote the success of the company for the benefit of its members as a whole, members meaning shareholders for the purposes. In performing this duty, however, the directors must have regard to the interests of other stakeholders, particularly those listed in section 172. Now, enlightened shareholder value, the doctrine enshrined in the Companies Act, whereby although directors must act in the way they consider in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole. In performing this duty, they must have regard to the interests of other stakeholders, such as employees, for example, or environmental protection, and the long-term consequences of any decision. The requirement to take various interests into account as part of acting for the benefit of the shareholders as a whole enshrines the concept of enlightened shareholder value. And we have various, because Cyprus should incorporate the theoretical dimension of enlightened shareholder value, there's no provision. It's interesting to take into account the rationale of enlightened shareholder value, which was explained during the legislative process of the UK Companies Act 2006. We have various speeches from the House of Lords during the adoption of section 172, which could be useful for Cyprus. Lord Goldsmith said, the company law review considered and consulted on two main options. The first was enlightened shareholder value, under which a director must first act in the way that he or she thinks in good faith would be most likely to promote the success of the company for its members. The government agrees this is the right approach. It resolves any confusion in the mind of directors as to what the interests of the company are and prevents any inclination to identify those interests with their own. It also prevents confusion between the interests of those who depend on the company and those of the members. And another extract from Lord Darling. For the first time, the bill includes a statutory statement of Director General duties. It provides a code of conduct that sets out how directors are expected to behave. That enshrines in statute what the law review called enlightened shareholder value. It recognizes that directors will be more likely to achieve long-term sustainable success for the benefit of their shareholders if their companies pay attention to a wider range of matters. Directors will be required to promote the success of the company in the collective best interest of the shareholders, but in doing so, they will have to have regard to a wider range of factors, including the interests of employees and the environment. And a few concluding remarks is that despite the fact, just to close this, one moment. Despite the fact that Cyprus still adopts the common law duty, which is a strict version of the bona fide duty and the duty to promote the interests of the company, it's possible the Cyprus courts to interpret this duty wider, taking into account and considering various aspects of the enlightened shareholder value. So the common law duty could be interpreted in the light of the UK legislative provision. And this is a very good way of approaching this absence of codification in Cyprus company law, because the courts would have wide discretion how to adjust the needs of the common law duty to the modern requirements of ESG and, of course, the various requirements of the directive. And it would be interesting to see if in the nearby future, there's going to be a legislative provision of course, a new legislative provision codifying not only this director's duty, but all directors' duties in Cyprus company law, like in UK companies law, would be the optional choice for the legislature. But we will see. It's interesting that at least Cyprus has as a source UK companies law, and it's possible the common law duty to be interpreted in the light of the requirements of Section 172, in the light of the requirements of UK statute. But of course, as I said, the optimal solution would be to have a legislative provision. Thank you so much for your attention. I hope I didn't violate a lot the time limit.
Thank you, Professor, for such an interesting presentation. So I think it's a critical point to understanding the liability of the director regarding this duty, because you have a general clause, not specific provisions. So it's so interesting, the point of view. And I just think that we can go directly to the next guest, and then if you remain, if you stay online, we can ask at the end of the panel if we have some questions.
Yes, sure, of course. Thank you.
Thanks again. So now I'm giving the floor to Professor Maria Giovannone. She's an associate professor at Roma Tre University, and she's more focused on the labor law perspective. So she will give us a presentation about labor rights as human rights and due diligence approach.
Okay, thanks a lot, Martina. And preliminary, let me say thanks a lot to Professor Mocella and to the scientific committee for accepting my paper today. And furthermore, thanks a lot for awarding me with this certificate of excellence. So it's really, I'm really honored. And furthermore, since it was really unexpected. So I'm really happy and thanks a lot. I'm sorry if in the afternoon I will have to go away because I have another commitment at Sapienza in Professor Mezzacapo master course. So excuse me for that. So I'm also putting my timer on, so I don't want to take too much time. So in my paper, I'm going to focus on some of the perspectives offered by Directive 1760 of 2024 as a crucial juncture in a broader and more complex process of regulatory tightening of corporate sustainability due diligence obligations. As we know, it's in fact a process that has long been called for, partly due to the initial regulatory experiments carried out in Europe at international level and beyond. And we know that there is still an ongoing idea of an international treaty concerning business and human rights, and maybe the development of the due diligence approach. I don't know which is going to be the final goal of this treaty. Anyway, what I will try to stress is the fundamental importance of two main aspects of this directive. We know that the directive is based on a very complex landscape, so many interesting aspects to be developed. But I will focus on two aspects which, in my view, seem particularly interesting in the view of the future and the next transposition at national level. First, the identification of the individual and collective rights of workers classified as human rights, which the directive itself addresses. And secondly, the introduction of new rights of participation and information granted to workers and their representatives in the prevention of potential infringements of such rights. So prevention, in my presentation, is a key word, since the directive seems to shift the center of gravity from the remedial action that is still very important and crucial in the protection against human rights infringement, but the idea of prevention is very strong, and this is a prevention which should be developed in a participatory framework, and that is particularly compliant with some already existing national instruments within the Italian landscape. So I've already anticipated some of my conclusions, but I want to go straight forward. We know that the landscape and all this despite, let me say, despite the legal basis of the directive, we know that the directive is deeply rooted within competition law and European competition law, not within the European pillar. And despite the limitations and the critical and highly criticized, we know, amendments introduced by the Omnibus Package 1, the restrictions introduced by Omnibus Package 1. So despite this landscape, complex landscape, I will try to put on the table three main questions. The first two questions are more strictly related to the perspective of international law and business and human rights regulatory approach. Since if there is any real progress in the labor rights as human rights debate with the adoption of this directive, and secondly, if there is any real progress in the involvement of non-state actors, including companies, obviously, in the human rights regulation and enforcement process, and finally, if there is any real potential for workers' participation mechanisms. Well, participation should mean something more than a weak consultation right. So these are the main questions, and maybe as I will show in my presentation, we can say yes to these tips, but with a few consideration anyway. So we know that as for the first question, of course, we can say that the directive fits within a process of progressive conferral on certain workers' right of the status of human rights. We also know that there is such a good international consensus around a fundamental set of rights, of labor rights, which could be considered human rights. But we know that this issue anyway remains open and problematic, not only from a labor law point of view, but first of all from an international law and human rights law point of view, especially when we move from the general principles to the effective protection of these rights against infringements due to the complex technicalities of the multi-level regulation and the judicial system. So that's why in this complex landscape, the possibility, in my view, given by the directive, even in the view of the next transposition at national level, of using organizational and management participated tools to prevent these rights from being infringed, appears very crucial and fundamental. So the directive also gives, as for the human detection technique. So we have to look very shortly at the human rights detection technique, since it's strictly related to the answer to the first question. We know that there is a list of human rights, a very broad list. There is no innovation in the content of these rights because the directive does not introduce new human rights, but the directive puts together the most important instruments already recognized and adopted at international level. But what is very interesting in the prospect of the first and the second research question I put on the table is that in doing so, even if the solution of enumerating human rights in the annex rather than in the body of the directive has been strongly criticized by the doctrinal debate, on the other hand, in my view, it seems to be very useful and pragmatic, since it seems to facilitate their possible amendment and supplementation over the time, where the supplementation could be done not only by the European institutions, as the directive itself states, but it's interesting because this amending process and supplementation process of the list of human rights is open to even to national institutions, so through the transposition process maybe, but also is open to the contribution of the non-state actors and private actors. So we can see that in recital 33, the directive states that depending on the circumstances, companies may need to consider additional standards. So this is another element bringing to a better involvement of non-state actors in the regulation and enforcement of human rights. And we know that this is very crucial in the development of the business and human rights regulatory approach for a better effectiveness of these rights, from the principles up to the the protection, the effective protection. Secondly, the directive also, we know, identifies an important number of individual and collective rights of workers catalogued as human rights. And what is another interesting element, very useful for answering the first question, is the introduction, maybe, of new rights of information, consultation, and participation for workers and their representatives as interested and even vulnerable stakeholders. So, despite the restrictions introduced by the Omnibus 1 package, I stress, I think that an idea of a participatory governance of enterprise risk, anyways, starts to emerge while shifting the center of gravity of protection from the action for compensation due to the violation suffered, which is still actual, obviously, to the prevention of the violation itself of workers' rights or human rights. And that's very interesting since this idea goes to strengthen the horizontal effect of human rights obligation, where we know that the horizontal effect of human rights obligation has been long discussed at doctrinal level in international law, and it's still controversial, but it seems to be one of the crucial points for the development of the due diligence from the soft law approach up to the hard law approach. Okay, so the directive seems to push national legal systems towards the operational and not only ideological introjection of sustainability within the national system. So it seems to complete the apparatus of the new generation duties of transparency, communication, and information outlined in other recent European legislation. Let's think about the AI Act, let's think about the Platform Workers Directive, but also the Gender Pay Transparency Directive. So it's part of a broader framework going to information, transparency, and communication, because it also introduces some specific information obligations and involvement of this wide range of stakeholders. So this due diligence obligation of means seems to produce an anticipation of the threshold of protection of human rights holder in a process in which, first, companies as private actors are directly involved alongside states in the process of realizing human rights. And furthermore, a set of first, second, third, and fourth generation human rights are finally put by the directive in the list on the same value and unequal footing. It's very interesting because we said that the directive was not innovative in the list, in the content of human rights to be protected, because it puts together already existing instruments, but the directive is new in putting all these human rights on an equal footing. And it's very interesting in the view of the future development, even at national level and not only multi-level regulation. So we have so many aspects concerning the omnibus package, but I cannot go through these aspects due to time restrictions. I don't want to overlap my presentation, but we know that there are some critical aspects that have already been analyzed during the keynote speaker's presentation. We know that some of these aspects are strictly related to the changes in Article 8 concerning the diligence risk management system, and this is particularly interesting in the view of prevention. I'm stressing, as you can understand, on the idea of prevention. So we know that among these aspects, one has been restricting concerning the possibility of collective representative actions. And this is detrimental to the idea of a participatory risk management prevention. Anyway, some expectations on participatory risk management, in my view, still persist. If we look at the broad definition of stakeholders to be involved, if we look at the idea of the form of stakeholders involvement adopted by the directive, since anyway the due diligence policy, all the due diligence policy must be developed in prior consultation with the company's employees and their representatives, and it must include the description of the company's approach, a code of conduct containing the rules and principles to be followed, the procedures put in place to integrate due diligence into relevant company policies and to implement due diligence. And there is an obligation to a full consultation of interested parties at several stages of the due diligence process, including the preventive moments. So, despite the Omnibus Package 1 restrictions, anyway, this is a crucial aspect still persisting, which is very functional to the future transposition at national level. Better if harmonized with the already existing instruments in the national legislations. Let's think about the national legislation concerning gender equality, the national legislation concerning health and safety. So many pieces of law could be put together to guarantee a better development of this idea and approach. I want to go to my conclusion, so I will skip some slides, as you can see, to the national situation. Okay, so what can we say about this approach so far? If we look at the Italian situation from an ex ante and ex post perspective, we can say that so far industrial relations and collective bargaining have not yet fully grasped the implications of ESG and human rights on rules and management of labor relations. We have some interesting examples that we can call best practices, of course. Some of them have been mentioned yesterday. The ENI Global Framework Agreements, the ENEL Global Framework Agreements on human rights, on labor and human rights. But if we look at the certain level collective agreements, we have just few ESG practices within the Italian territorial and company level collective agreements, inspired to the UN Agenda 2030, with a specific relation to the goals 5, 8, and 12. And we have some important pushing factors coming from the recent transposition of the Directive on Corporate Sustainability Reporting. But some interesting challenges in the view of the national development of this participatory approach promoted by the directive could be given by the recent law 65 of 2025. Because we know that traditionally the Italian system is not based on a very co-managerial approach when looking at the industrial relations. Maybe this law could promote a new approach. We have a tradition of a more conflictual industrial relations system, but maybe putting together the transposition of the directive, of that peculiar aspect of the directive, promoting the involvement of workers and workers' representatives, together with the application of this new law, could bring to the development of a new approach and to the development of this participated prevention and managerial approach with the full involvement of workers and their representatives. So this directive, of course, is going to have a widespread impact on business management practices, since it responds to a new vision of companies. And I agree what Professor Pizzoferrato said yesterday. Of course, we need formal transposition laws, of course. But in this case, this is an area where company practices based on the involvement of the stakeholders and moreover of workers' representatives is going to giving such an important boost to the development of the approach, of this aspirational approach that the directive anyway has put in place. So this is a bet. We know that this is a bet, and to win this bet, the directive provides for the contribution of all stakeholders, first and foremost, but not only trade unions, involving them in the procedures for assessing and mitigating risks to rights and the environment. So, concluding my speech, we can say that from the overall perspective, the directive seems to mark an interesting turning point in the complex disciplinary sphere occupied by human rights law. It adds an important piece to the controversial issue of the horizontal enforceability of obligations arising from human rights. This is in spite of a traditionally vertical vision, we know, that places these obligations exclusively on states. It emphasizes the obligations of means as the essence of the obligations arising from human rights. And it also supports a corporate risk assessment and participated procedure aimed at preparing an adequate organizational setup. So this puts at the center, in my view, industrial relations and the role of industrial relations and workers' participation, not just as a weak consultation procedure. Anyway, we need to work a lot, not only through the transposition law, but more and more through company practices. Thanks a lot for your attention.
Thank you, Professor. It was a really clear presentation. You gave us a lot of indications on the directive in the critical aspect, but also the perspective, the open field that remains beyond the law.
I'm an optimist. So.
and I think, of course, that one point, one of the most important is the workers-driven due diligence. So talking about information and consultation, industrial relations, and I think it's interesting that this is real a point of in common with the next presentation. So it means it's a really important point that you highlighted. So let's see what can we understand about a specific point of the European Working Council, that, if I understood, it's the point of your presentation. So I'll give the floor to Professor Veronica Verzulli. And you presented the abstract with colleagues from Roma Tre University. You are a research fellow at Roma Tre University. So Maria Laura Santonicola, but she's not here. She couldn't be here today. So you have all the responsibility.
Due to health problems. So.
No, of course. Thank you. And
Thank you. It's very hard to speak after Professor Giovannone, but good morning, everyone, and thank you for getting me involved in this initiative. With my presentation, I would like to reflect on the potential role of European Work Councils in the implementation of due diligence policies. This is because these councils have rights to information and consultation on transnational issues within multinational companies. The issue seems relevant now, given that Directive 2450 was adopted with the aim of revitalizing these bodies in the face of a decline in the number of newly established councils in recent years. So we don't have time to analyze all the changes. I should focus only on the definitions. Why? Because the new directive clarifies the definition of transnational issues falling within the scope of the Council's rights. In particular, the definition now includes, for example, situation involving collective redundancies or outsourcing of activities implemented in a single state, but within an impact on workers employed by the same company in another member state. This is a common scenario, particularly due to changes in cross-border supply chains, as the directive itself states. Consequently, even formally national issues may fall within the Council's competence if they affect workers in another member state, and it is intended to address elusive corporate practices known as the salami tactic. In such cases, companies adopt similar measures in different states, countries, so national measures in succession in order to avoid their transnational nature. So, however, even the 2025 directive fails to address the most sensitive issue, which is the lack to recognize the negotiating role of these councils. In this way, the directive reproduces the distinction between participation and collective bargaining. Participation being the prerogative of the councils and also trade unions, while collective bargaining only falls within the competence of trade unions. Actually, the bargaining practices go beyond this distinction. Indeed, the information and consultation process has often led to the adoption of joint documents, joint statements, transnational agreements, but also code of conduct, code of ethics, strategic plans. So typical tools of corporate self-regulation, but subject under the social control of this channel of representation. And through this framework, in many best practice cases, the councils have played an active role in discussion on many issues relating to corporate social responsibility. For all these reasons, the councils appear to represent a strategic forum through which to achieve the involvement of workers and their representatives as required by the recent directive on due diligence. How these bodies could improve cross-border coordination between the representatives involved in the preparation, implementation, and monitoring of corporate due diligence policies. As labor law literature reminded us a few years ago, the councils could facilitate a vertical and horizontal flow of information between European work councils, company units, and national trade union representatives. To this end, it is interesting to note how, over time, the councils have established channel of communication with trade union federation. I'm thinking of the role of the sectoral coordinator. Also, we might mention the global work councils, which have open participation to non-European workers employed in subsidiaries worldwide. As we know, the due diligence directive integrates a typical corporate social responsibility instrument into the risk management system imposed on companies, in particular code of conduct and the system of contractual guarantees. And we know that these tools could become cosmetic compliance measures designed to avoid obligation or for reputational purposes. But at the same time, the directive requires the involvement of workers and their representatives in the design and implementation of this risk management system, as explained by Professor Giovannone. And it is for this reason that the Council could ensure a certain degree of social control at an upstream level over the adequacy of these tools, which have long been tested by these bodies using a bottom-up approach. To give just an example, to give just one Italian example, as mentioned by Professor Pizzo Ferrato yesterday, the Global Framework Agreement of Eni, an important national energy company, is particularly emblematic. This agreement was recently renewed in 2026 and was promoted also by the Eni's Council. In particular, the agreement tries to anticipate new due diligence obligation by establishing a classification of suppliers based on country risk and business risk, and by providing for the inclusion of due diligence clauses in commercial agreements. At the same time, the agreements established the creation of a human rights risk management system with the involvement of workers' representatives and other stakeholders, such as local community, for example. Most importantly, these instruments are subject to a monitoring mechanism involving Eni's European Work Council and trade union representatives. Therefore, the agreement adopts the multi-stakeholders approach promoted by the directive. Yet, the perception is that the role of European Work Councils continues to be underestimated. As several voices have pointed out, the due diligence directive doesn't establish a link with this channel of representation. However, we might say that the hardening process of due diligence requires legal system, but also industrial relation systems to move beyond a local perspective. This would also require setting apart jealousy over trade union and national negotiating powers. These local prerogatives remain essential, but without an European coordination, they risk being undermined in the face of this strong interrelation between national labor markets. Also, European legislation places great emphasis on promoting corporate self-responsibility through accountability, through risk-based approach, and not only on the ground of due diligence, but also in the field of AI, for example. So direct to information and consultation on the decision-making processes of companies are fundamental to ensuring that workers' representatives have the power to understand how the company is managed. This also represents an opportunity for national trade unions. They should overcome their mistrust of form of supranational participation, not least because internal European participation is not a means of eliminating form of external participation, which are conflictual and deeply rooted in the Italian experience, in the Italian tradition, for example. Actually, understanding how a company operates increases the possibility of success in terms of conflict action, in terms of remedial action. The work of the European Work Council can only be one element of these strategies, but best practice have showed that the rigid dichotomy between participation and bargaining and negotiation at supranational level has been overcome. This is because in the most successful cases, this representation channel have created a continuum between information, consultation, participation, and bargaining on due diligence issues. Thank you.
Thank you. It was really, really interesting, and you highlighted very well the two points. So having involving the importance of involving workers in the risk management system, and in the same time, on a trade union perspective, having local actions with a European or maybe also global coordination, but of course, European Working Council. Maybe I just wonder if the reform of the directive missed some content in this perspective. So let's see what we can do with the next draft. Now I'm giving the floor to Camilla Benevides. Camilla is a colleague at Mercator University. She's a postdoctoral researcher, and she will focus her presentation on the concept of workers in the CS, the directive. So thank you, Camilla.
Thank you, Martina. Good morning, everyone. First, I would like to acknowledge the great work of the organizers of this event, and I would like to say that I'm really glad to participate. So, as Martina told us, I will talk about the concept of worker. And first, I would like to say that I think we all agree that the due diligence directive represents an important step in protecting workers and promoting responsible business conduct. But today, my presentation is not about the rules created by the directive, and I would like to talk about one interpretative problem. So my research starts from a simple question: which companies were required to comply with the directive? The Article 2 applies that the directive is applied to companies employing more than 1,000 employees. It's important to mention that there are also other criteria, such the company's turnover. But however, in this presentation, I will focus in the criteria based in the number of employees. When we think about the criteria, about 1,000 employees, at first, it looks very simple to understand if a company is or not applied by the directive. But when we start to consider different employment contracts, atypical workers, and different definitions of worker in each member state, the situation becomes more complex. So specifically, my question is, who should be regarded as a worker when calculating the amount of 1,000 employees? For example, part-time employees could be considered, temporary workers could be considered. First of all, I think that it's very important to clarify that this issue only concerns companies established in the European Union. Companies established in third countries are subject to different applicability criteria under the directive. Therefore, the European legislator expressly decides that employees working at branch located in third country should not be included when calculating the amount of 1,000 employees. However, employees working in different member states of European Union are included in the calculation. There are some important informations that we could find in the recital 27. It explains, for example, how temporary agency workers and posted workers should be counted. And it also refers that workers in non-stand forms of contract of employment should be considered too. So the same recital states that non-standard workers must be included if they satisfy the criteria of worker established by the Court of Justice of European Union. And this is my key point. Okay. Why this is the point of my presentation? Because the problem is that different member states classify workers in different way. Therefore, the same activity may be considered employment in one country and self-employment in another. For example, we know the Just Eat example, it's an Italian example, because in 2021, riders engaged by the company in Italy were classified as employers because in a collective agreement that was made in that period. So in the same period, another member state's works performing essentially the same activities for the same company were classified as self-employed. In a situation such as this, how should the number of employees be calculated by Just Eat for the purpose of the directive? Would it be fair to consider only in the amount of 1,000 employees, only the Italian workers and that were classified as worker? I think that we need to understand the legislative choice. Unlike another directives, the due diligence directive does not refer to national definitions of employment. Instead, it refers directly to the status of worker created by the Court of Justice of the European Union, as you can see in the text. And this is the question. What are the criteria developed by the Court of Justice of the European Union for determining the status of worker? And the answer is, in my research, I found that there are two main approaches in the case of law of the Court of Justice. The first one is concern directives that expressly refer the national law in defining the existence of employment relationship. One example of this kind of directive is, for example, the Transparency Directive. But it's not the case of the due diligence directive, so I will not talk about it. The second approach applies where the directive does not refer to national law, and as I said before, is the case of the due diligence directive. In this case, the court applies an autonomous concept of worker. So we are talking about a concept of worker created by the court. It's important to say that the court said in a lot of cases that there is no single definition of work in the European Union. Rather, the concept applied by the court varies depending on the legal context in which it is applied. For example, even though there is no concept in European Union, when the court needs to decide if there is a status of worker, or if you are talking about self-employment, usually the court analyzes 3 elements to define a worker. These elements are genuine and effective work, remuneration, and a relationship of subordination. Here I have only summarized these 3 criteria. In the full paper, I discuss in detail all the relevant judgments of the Court of Justice that have shaped these 3 criteria. Another principles are also considered by the court. For example, even though the contract was called or named as a self-employment contract, that is no important because they analyze if in the practice there is or not subordination. And another important information is that part-time work, short duration, or low remuneration do not automatically exclude the worker status. But what are the practical consequences of this autonomous concept created by the court? The problem is that each situation must be assessed according to real facts. So it means that companies may still face uncertainty when they have to calculate the 1,000 employee amount. My conclusion is that as we have seen, the concept of worker developed by the court does not necessarily agree with the classification adopted under national law systems. Moreover, it continues to evolve on a case-by-case basis, depending on the specific objective pursued by the relevant provisions in the European law. So, within corporate groups operating across several member states, uncertainty may still arise as to which categories of workers should be included when calculating the amount of 1,000 employees, particularly in relation in atypical forms of work or categories whose legal status differs from one member state to another. In order, I think, to ensure a genuinely uniform application of the directive, further interpretative classification or future information guidance would be highly desired. Such a guidance to define more precisely the criteria for calculating the number of employees for the purpose of the directive. So I would like to thank you for your attention.
Thank you, Camilla. And as I said before, really, those presentations gave us an in-depth vision of different aspects of the due diligence directive and different critical aspects too. And this point is also so interesting. And I think that the European Union, again, missed the point because considering the long-term integration of at least solo self-employed means that you have to consider the fact that it's an indicator of the dimension in an economic point of view, but also in an organizational point of view regarding all the obligations of the due diligence. So it means it's a big company, even though you have to consider the solo self-employed workers, as the case of riders in Italy. So I think we can stop with this the first presentation, but we have 2 more presentations in this panel, and then after those 2 presentations, we can ask the public some questions. Or what? Or do you prefer, now that you're here, maybe I think it's better to ask if we have later. Okay, so it's a problem of time. Thank you again. Really. Abbiamo altri due. So I will ask to come here. Sì, sì. Big Z Oliveira and Parvin Morris. Okay. Big Z Oliveira, I don't know if he's online. No. So, Camilla.
Good morning. Can everybody hear me?
Yes, we can see you. We can see you. So,
Can you hear me?
yes, we can hear you.
Thank you.
You can hear us. So,
Thank you.
okay. Just a few minutes, we will resolve some problem, and then I'll give you the floor.
Okay, thank you.
Okay, you can share the screen for the if you have slides and you want to present with your slides.
It's not necessary.
Okay,
Okay?
good. So let's go straight forward to the next guest, even though a remote guest. Alexia Bizzi Oliveira from Brazil, Federal University of Espírito Santo. So, as I said, we have also perspective of states different than European Union member states. And I give you the floor, Alexia, and thanks for your participation.
Thank you. First, I would like to thank the organizers for this opportunity and all of you for being here today. I present with my professor, Claudio. We appreciate the opportunity to...
Sorry, I didn't present also the professor, but then you can
Yes.
you can do for me. Thank you.
We appreciate for the opportunity to participate in the founding of the founded by European Union with Università Mercatorum, represented by Professor Marco Mocella. Is right? This is an important event for discussing sustainability, ethicals, and due diligence regarding environmental, social, and governance issues on a global scale, as well the implementation of European directives. My name is Alexia. I am a master's student in procedural law at the Federal University of Espírito Santo, Brazil. Today, we will present our research developed by my Professor Claudio Ianotti da Rocha, my supervisor, and me. Our research is about digital child labor and how the idea of the transversal process can help protect children's rights on digital platforms. We use a case study, the recent agreement between Meta Platforms and the Brazilian Labor Protectors Office. Child labor is still a major problem around the world. According to the International Labour Organization, about 160 million children are involved in child labor. Today, social media has created a new challenge. Many children become content creators. Their videos and daily lives can make money for families, companies, and digital platforms. But this work is usually seen as entertainment, not a work. Because of this, many cases are never identified. Our research asks one simple question: how can the transversal process help digital platforms better protect children? Our main idea is the law should not only recommend good practices, it should also make digital platforms responsible for protecting children's rights. The agreement between Meta and the Brazilian Labor Protectors Office is a good example. Meta agreed to identify accounts, age verification, and create reporting channels. These measures help prevent the economic exploitation of children online. This agreement follows important international standards like human rights, the OECD guidelines, and the European Union due diligence rules. These standards say that companies should identify, prevent, reduce, and repair human rights risks. The Meta agreement shows that these international ideas can become real legal duties. The theoretical basis of our research is the transversal process created by my professor Claudio Iannotti. The idea is simple. Problems like digital child labor cannot be solved by only one area of law. They involve labor law, children's rights, technology, psychology, sociology, and constitutional law. The transversal process brings all these areas together. The Meta agreement shows this is practical. It identifies risks, creates preventive measures, improves monitoring, and establishes legal responsibility when the rules are not followed. In conclusion, our research shows that the transversal process can connect international human rights standards with national legal action. The Meta agreement proves that digital platforms can have real legal duties to protect children. It also shows that protect children requires cooperation between governments, digital platforms, and experts from different fields. I will now hand over to my professor Claudio in online too, and thank you very much for your attention, everybody.
Thank you. Thank you. Professor, do you want to continue? You have some other remarks. Thanks.
Of course. Great. I am a professor at the Federal University of Espírito Santo and Alexis Professor Advisor. Child labor is prohibited in Brazil for the under the age of 168. It remains widespread. Children labor is problem in Brazil of the under the age of 168. It remember widespread. Below this age, judicial authorization is mandatory as will now the work is detrimental to child's well-being. Child labor is not only a reality in Brazil, but is also on the rise. Typically, it takes place within the home, utilizing new technologies and involving the help and encouragement of parents. Work conditions in this context are precarious, exposing children to hazards such as extreme heat, dangerous situations, and even user-hardened environments. This type of the work is practically difficult for official bodies to monitor, given that it is performed inside at the home. Hence, the need to implement a transversal procedural approach and innovation that allows the law to engage with other sciences, such as medicine, psychology, engineering, and sociology, to combat child labor. Legal proceedings must examine the employment relationship, subordinated work with digital platform companies. After the are the honest betterments from child labor facilitated by new technology, and they are responsible for ensuring proper work conditions. Child labor and the responsibilities of platform companies constituting a sustainability and ethical issue that must be addressed globally. It's a problem affecting every country in the world. Only the wheels are veneer of normality it is far from normal as it involves the future of humanity itself. ILO Conventions 138 and 182 regulaments child labor and must be applied to child labor on digital platforms. Furthermore, new up-to-date conventions should be created to address this new global reality. Only that is not only a reality but is also rapidly expanding worldwide. For us to have a better world, it's essential that children be protected, and addressing child labor in this context of now technology is certainly on the real necessities for sustainability. To aid a better world, it's essential to protect children. Addressing child labor in this context of new technologies is a genuine sustainability imperative. Institutions must implement governance and due diligence plans permitting child labor on platforms only when authorized by a judge, and is such cases strictly guarantee the child's rights to health and safety. I finish we not palestron, and we very happy because in participation this Congress.
Thank you. So it was evident that the issue of due diligence becomes even more complex when it comes to digital platforms. And as you have highlighted, it's important, the role of also other disciplines and other sciences. And the problem is also how to support trade unions with experts, because their job will be more difficult in understanding the functioning of the algorithm and all the issues related to the functioning of the algorithm. So thank you again. And our last presentation of the panel, Professor Parvin Morris, lecturer at the University of Manchester. Now we will focus on the remedies perspective. So thank you. I'll give you the floor. The slide? Sono quelle che mancano. It's correct, no? Sorry. Is that just okay. No, it's ready. You can. If you can go, if you can move to the next. Okay. Oh, not yet. I'll mention. Ok, you will mention to him one at a time. Perhaps lui dirà quando cambiare la slide. Okay, thank you.
Good morning, almost afternoon, I think. I'm Parveen Morris from Manchester in the United Kingdom. And thank you to the university for allowing me the opportunity to present these insights today. And it's been really interesting to hear the presentations that have already taken place. One of the papers this morning was speaking of kind of preventive measures. So I suppose now I'm taking the kind of alternative of I suppose, accessing remedy. So it's more after the event, I suppose, where a victim can show that they've suffered harm. So I want to focus on the civil liability regime under Article 29 of the European Directive. As this is the principal provision that governs access to remedies for victims who have suffered harms in supply chains. But I'd like to just raise, of course, an immediate caveat on account of the omnibus proposals under which the harmonized civil liability regime is to be removed and which instead mandates for remedies to be pursued through member states' national courts. So I don't plan to speak about the omnibus proposals because I know that is the object of the next panel, but it's just to kind of draw attention to it. Just kind of briefly, obviously, the justifications for these are, as was kind of raised yesterday, to create a more competitive environment for businesses in the union. However, from my kind of perspective, which is really anchored from the lens of the victim, this presents a considerable downsizing to the removal of the harmonized regime when it comes to pursuing civil liability. Despite what I've just said, I still plan to ground my comments into Article 29, given that what it contains is very likely to mirror what is contained in the national regimes of member states. So I will still pursue with the provisions of Article 29. Next slide. So just to start off, I just want to kind of say a word about Article 29 and the importance of it, given the, I suppose, the permitted prioritization of breaches in the European Directive. And I will then move on to kind of exploring some of the limitations of the regime, followed by some just kind of final observations. So yeah, first of all, minimum civil liability. Of course, we know it's a landmark initiative and very crucial aspects of the enforcement mechanisms of the European Directive, given that it offers a route to victims to pursue corporations in their home states. Now, I have written about this, particularly from the angle of victims in least developed countries. The upshot of that was to really kind of spotlight the importance of it for victims who would really perhaps struggle from accessing internal or domestic complaints mechanisms, perhaps because they're ineffective or because they're inaccessible. Now, I appreciate that this isn't just a difficulty, perhaps that's going to be faced by victims in least developed countries, but that's just an angle that I pursue because these problems can be kind of compounded in the least developed economies. Turning to the context of the European Directive, just to anchor the importance of civil liability into the permitted prioritization of breaches of due diligence. I just wanted to point out here that as the directive permits corporations to prioritize the most severe adverse impacts, and I know there will be arguments kind of supporting that this is done rightfully. I'm not here to kind of debate that. I'm just here to point out the practical impact of this, which is inevitably going to mean that many labour harms will receive little to no attention. So within this context, civil liability is a key mechanism for obtaining redress for harms, perhaps where there's nowhere else for the victim to go. Slide number 3, please. So just a snapshot, accessing remedies. It's for obtaining compensation for harms caused by a failure to comply with due diligence duties. The idea is to really incentivize corporations to embrace due diligence, move away from box ticking and just paying lip service to their obligations, perhaps which might yield in just ticking a box, after obtaining a contractual assurance from business partners. Also, it's a route to the court system, as I've just mentioned at the outset, where perhaps complaints procedures could be remote or inaccessible. But there are tensions, which we will now turn to. Key tension, that the route to compensation is a narrow one. And I just want to kind of detail this by drawing on the specific requirements under the regime, in terms of the requirements being proving breach, that there has been fault, that the victim has suffered damage, and the crucial aspect of causation. So just turning to this very kind of brief snapshot or an overview of the legal requirements. We know that it obviously only applies to in-scope companies, so those EU corporations that are caught by the thresholds, and non-EU corporations that fall within the thresholds were subject to the duty of due diligence, and requirement for there to be a breach with a fault. Inevitably, there's been damage suffered by the victim, and importantly, that the victim can approve compensation, which will lead to compensation, subject to full compliance, cumulative compliance with those requirements. Next slide. So again, it's key to kind of point out the cumulative aspects of these requirements. Just turning kind of to the specifics of the limitations built in here, the claimant must show that the corporation breached its due diligence obligations, namely that the requirements, that the breach caused damage. Sorry, it's just an overview. I just want to spotlight here the difficulties with proving these aspects. And this was something that was kind of also raised yesterday in the context of the French liability regime. And I suppose we're kind of seeing a similar kind of situation here in the European regime. Because if you have harm, we know that this in itself is not going to be sufficient. It's a matter of proving that the corporation has failed to act, and they have acted with a lack of sufficient care, or that they have acted intentionally. The key being here that the victim has to prove these aspects. And I will turn to kind of proving through disclosure in one moment. But before I do that, just spotlighting the causation requirement. The corporation will, of course, not be liable where damage has been caused solely by a business partner in the chain of activities, which the impact of which is pretty huge if we think about the workings of global value chains. And again, where labor abuses could be in fact, are pretty far removed and remote from the lead corporation, which inevitably leads to a narrowing of claims, as we have seen under the French regime. Has to be said, of course, that the directive permits joint liability, where we have harm that's caused by a company alongside its business partners or subsidiaries in its chain. But again, this could be difficult to prove. And I will, in my final reflections, just comment on the omnibus proposals impacting indirect business partners and SMEs, which makes this all the more convoluted and difficult. Next slide, please. So the next spotlight on the burden of proof, which is placed largely on the shoulder of victims, whereas there are strong arguments for placing this on the shoulder of corporations. Of course, there is debates to be had on that. But just moving kind of on from a victim's perspective, the claimant is to produce reasonably available facts and evidence that's sufficient to support the plausibility of the damages claim. Under Article 29, there is the possibility of applying for an order for disclosure of evidence against the corporation to allow for the victim to be able to demonstrate the breaches in order to successfully tick the boxes for obtaining compensation. However, of course, victims are less likely to be able to articulate specific evidence and about the corporation's due diligence practices, or indeed from the internal decision making of business partners in the chain of activities. Corporations themselves are far better placed to be able to disclose what they have done themselves in their due diligence systems, and so inevitably it has been argued that the European regime has missed an opportunity. Turning to the specific aspect of disclosure, the disclosure of evidence. So it has to be said that even if a claimant produces or persuades a court that disclosure is justified, disclosure is going to be limited to that which is necessary and proportionate. Yes, it's arguable that these limits are needed, of course, to protect businesses from spurious claims and to avoid burdening them. Of course, these arguments have great merit, but the alternative position must be conceded that this could have a potential nullifying effect on potential victims. A further point in relation to disclosure, which should be raised, is on account of the protection of confidential information and trade secrets, which the directive safeguards. Again, business certainty, of course. Another potential loophole, however, in terms of corporations being able to perhaps develop sophisticated legal arguments in order to fend off claims for disclosure, which just perhaps gives a lot of space to companies, even in the event of orders that should be granted. So final word is that Article 29, despite the omnibus proposal, presents practical barriers. It's far from free of limitations. And this is likely to be kind of replicated within the national systems of member states' civil liability regimes. We can see how there can be a serious narrowing of claims through the adoption of sophisticated legal arguments, because proving intentional conduct could inevitably require extensive disclosure, which could be very difficult to obtain. So just some kind of final words of reflection. Yeah, just a few final words of reflection on this is that what we're now left with under Omnibus is that indirect business partners are, carved out, which means that the lead corporation is very unlikely to obtain information, again, equally with SMEs, to avoid burdening them. It's unlikely that there will be any kind of particular deep detail that the lead corporation can obtain from an SME. Again, really, really watering down the potential for victims here. But also, again, on a final word, the omnibus proposals is in the package is for revoking the obligations on representative actions by trade unions and NGOs, which pretty kind of instrumental, particularly for the victims in those least developed countries, denying, of course, has to be said, denying effective access to remedies for victims who have been subjected to violations of their labour rights in supply chains. I think that's all for today. Yeah, thank you very much for listening.
Thank you. So I think a critical aspect is the issue of a procedural perspective regarding the difficulty victims may face in asserting their rights, in a procedural point of view. So whether it is important to ask, for example, trade unions to have a legal representation for help victims in the judicial part. So thank you really to all the speakers. It was a really interesting panel, and even though we were running out of time, I will ask the audience if they have questions, and maybe so the speakers may come back here just to give the answer. So any questions? Bas, thank you. Can we? Okay.
Thank you. And this is working? Okay, so I have a question for Camilla. So thank you for your presentation, and I think it was very insightful, very nice topic that you discussed. So if I'm correct, you're suggesting that there should be more guidance on who should be included in the scope, right? I think this could go two ways. Either you're going into a very technical and very detailed analysis of what kind of categories of workers should fall inside or fall outside the scope, or you could go maybe a more general way and look, for instance, at how the ILO defines this. They just say all workers, right? All people in the world of work. So what would be your preferred next step in order to come to a more workable delineation of the scope? Thank you.
Vieni, poi prendi possesso.
Thank you, Professor, for the question. It's very interesting. I prefer the second option, as Professor Martina also commented before my presentation. I think it will be better if we consider all workers, even though the self-employees, for considering the amount of 1,000 employers. I think the companies, the idea of the directive will be consider the biggest companies that we have today. So for me, the second option, when we consider all the workers, will be the better option. So thank you for the question.
No more question? Here too. Okay. I hope he's here. So
all right.
Yes, I can see.
So Thomas, thank you very much for your insightful presentation. I was taking notes during your speech, and you mentioned at the beginning of the presentation the issue of the implementation of the S.E.E.D, the directive in Cyprus, and then you explored the interplay with directors' duties, and you made the case for an evolution of directors' duties towards the enlightened shareholder value approach as reflected in Section 172 of the UK Companies Act. Now, my question is, do you see perfect complementarity between the S.E.E.D and the enlightened shareholder value approach, or do you see some room for conflicts between the two? And I'm asking this because you mentioned the debate that led to the approval of Section 172, and two different approaches were considered. The first approach was the pluralist approach, where directors' duties are bound to balance different competing interests, and then eventually Section 172 now reflects a different approach, enlightened shareholder value, where different interests, stakeholder interests are subordinated to the interest of shareholder, right? So under Section 172, this list of interests is only functional to the promotion of shareholder value. But under the risk management systems of the S.E.E.D, the adverse impacts should be managed in the interest of affected parties, so in the interest of stakeholders. And for instance, these impacts will have to be prioritized according to their relevance, not to shareholders, but to the stakeholders. So I wonder whether you see any conflicts between enlightened shareholder value and the directive. Thank you in advance.
Thank you very much for your very interesting question. First of all, Cyprus is still being prepared to implement the directive. I was not clear, I'm sorry. So there are still various drafts and various preparations for this. The crucial point here, the challenging point also from a comparative law point of view, is when your mother jurisdiction was evolved, but the subsidiary jurisdiction, let's say, remains a little bit behind. So this is the case of Cyprus. We have the UK law that was evolved, and we have a specific legislative provision. But in Cyprus, we have the old common law based on case law, which does not incorporate sufficiently. And this is the big challenge currently for the judges, because there are no plans to introduce a legislative provision on enlightened shareholder value. So the judges and the Cypriot judges should interpret the old style common law duty according to the new standards of the provision, of the new provision. So you interpret the old law of your mother jurisdiction according to the new evolution of this law, which is a little bit contradictory, but gives, I think, space to the judge to evaluate and maybe to adopt an autonomous approach sometimes when it is necessary, because it is not bound, totally by the interpretation of common law. Common law could be adjusted, obviously, because we're talking about two different jurisdictions, despite the strong connection. So I think that it is it would be very challenging for the judge to interpret this provision. And of course, the judge could take into account this contradiction that you mentioned, the differences between the theories on enlightened shareholder value and all this debate. It depends on the approach of the courts. But this, I think, is not very problematic because the directive, the CSRD directive, gives already space and margin of appreciation to member states regarding directors' duties. Unfortunately, this provision, fortunately or unfortunately, depends, this provision of the first drafts of the CSRD was deleted regarding directors' duties. So now there is more space and more margin of appreciation for member states and national authorities and also courts. And I think it's possible for the judge to evaluate and to take into account various contradictory or maybe topics that are under debate. And I think it would be interesting for the judge, and it would be very the judge could adopt the optimal approach regarding the director duty. So this is maybe a path to the optimal approach interpretation. I don't know if I covered your question.
Thank you again, Professor Papadopoulos.
Thank you so much.
I think we can close this first panel. We have time for a small coffee break, or we have to go straight forward the panel 2. So thanks again. Possiamo cominciare? Ci sono tutti? Marco Sala. Can we start? Good morning, everyone. First of all, I would like to thank Professor Marco Mocella and Universitas Mercatorum for the opportunity to be here today
and to discuss these important issues with you. It is a great pleasure for me to chair this panel on the omnibus reform and the future of the due diligence. I believe that the topic of this panel brings us directly to one of the most important questions in the current European debate. How can we simplify regulation without simplifying responsibility? Due diligence emerged as a response to a fundamental problem of our time. In the global economy, production is increasingly fragmented across companies, contractors, subcontractors, suppliers, and different jurisdictions. Economic power can easily cross these boundaries, while legal responsibility often remains confined within the formal boundaries of the individual company. Due diligence regulation has tried precisely to address this gap between economic power and legal responsibility. Today, however, we have entered a new phase. The omnibus reform is presented in terms of simplification, competitiveness, and reduction of burdens of companies. These are certainly important objectives, but from a labor law perspective, we must ask a further question. What exactly are we simplifying and for whom? Because if simplification weakens obligations, monitoring mechanisms, responsible disengagements, or access to effective remedies, its consequences may go far beyond the reduction of administrative burdens. It may directly affect the ability of workers and other affected people to prevent harm, identify responsibility, and obtain effective protection. So, in my view, the underlying question is not only what the law requires companies to do, but something more fundamental. What kind of responsibility can Europe law actually impose on economic actors operating throughout increasingly complex and fragmented global value chains? I would like to leave this question as a common thread for our discussion today. And with this question in mind, I am very pleased to open our panel and to give the floor to our first speaker, Paola D'Assisti from University of Trento. Paola.
Good morning, everyone, and thank you very much to the organizing committee for the opportunity to present my paper today. In this presentation, I will focus on the recent evolution of the EU corporate sustainability law, and more specifically on the impact of EU Omnibus Package 1 on corporate due diligence and supply chain governance. The starting point of my analysis is a tension that has become increasingly visible in the most recent development of the European legislation, the relationship between sustainability and competitiveness. Over the past decade, EU law appeared to overcome this traditional tension. Sustainability was not presented as a value to be pursued at the expense of economic activity. Rather, it was increasingly understood as a condition for the long-term competitiveness of European companies. Several instruments, from the Green Deal to sustainability reporting and the due diligence legislation, seem to move in this direction. In this framework, sustainability was not merely a matter of disclosure or corporate reputation. It was gradually becoming part of corporate organization, risk management, and governance. The adoption of the corporate sustainability due diligence seemed to represent a further step in this direction, in this process, by promoting a more transformative model of sustainable corporate governance. However, the subsequent adoption of the Omnibus Package 1, including the so-called Stop the Clock Directive, has changed this picture. These recent reforms postpone, simplify, and narrow some of the obligations originally introduced in the field of sustainability reporting and corporate due diligence. From this perspective, two possible readings of the Omnibus package can be identified. According to the first one, the reforms is mainly a technical simplification of existing obligations. According to the second, it can represent a retreat of the EU sustainability agenda. But neither interpretation seems fully correct. The Omnibus package is neither a mere technical simplification nor a complete retreat from sustainability. Rather, it reveals a deeper transformation in the relationship between sustainability and competitiveness. Sustainability is not abandoned. However, is no longer presented as the precondition for long-term competitiveness. It's treated as a value that can be balanced against the economic strength, proportionality, and regulatory efficiency. These shifts affects corporate governance in several ways. It concerns, first of all, the director's duties. Second, the role of stakeholders and the contractual relationship through which the European companies organize their global supply chains. In order to develop this argument, I will proceed in 4 different steps. First of all, I will look at the supply chains as the main space in which corporate sustainability obligations operate. Second, I will consider the role of stakeholders in the due diligence process. Third, I will examine the relationship between sustainability and directors' duties. Fourth, I will focus on the contractual mechanism through which sustainability obligations are extended along the supply chains. Let me start with the first one, the supply chains. One of the most important features of the S.E.E.D is that it doesn't look only at the individual company as an isolated legal entity. It looks like at the company as part of a broader network of productive and commercial relationships. This is important because many human rights and environmental impacts occur outside the formal boundaries of the lead company along the production, distribution, and supply chains. For this reason, the due diligence model introduced by the S.E.E.D is based on the idea that companies must identify, prevent, mitigate, and where necessary, bring to an end the adverse impact connected not only with their own activities, but also with the activities or their business partners within their supply chains activities. This is a crucial development. It shows that the legal boundaries of the company are no longer sufficient to identify the relevant area of corporate responsibility. At the same time, the final text of the S.E.E.D already reflected a certain awareness of the economic burden of sustainability obligation, especially through the concept of chain of activities and through specific limitations for regulated financial undertakings. The omnibus package goes further in this direction. It confirms that the European legislator is concerned not only with the effectiveness of sustainability obligation, but also with their economic sustainability for companies, especially for small and medium-sized enterprises. This doesn't mean that the supply chain disappear from the regulatory framework. Quite the opposite. Supply chain remains central, but the questions become more selective. How far should the due diligence obligation extend, and through which legal instruments should they operate? This brings me to my second point, the role of stakeholders. The S.E.E.D gives stakeholders an important role in the due diligence process. Stakeholders are involved in the identification of the adverse impacts, in the development of preventive and corrective action plans, and in monitoring of effectiveness of the measure adopted by the companies. This reflects a broader trend in the EU corporate law. The idea that the corporate decision-making should not completely close within the relationship between directors and shareholders. However, the stakeholders do not become decision makers within the companies, nor does the S.E.E.D create a model in which the stakeholders' interest is placed on the same level at the shareholder interest. Rather, the stakeholders provide information, take part in the consultation processes, and may activate accountability mechanism. In this sense, the stakeholders' involvement is a procedural function, because it improves the quality of the due diligence process, helps company identify less visible risk, and increases the transparency of corporate conduct. But it doesn't in itself redefine the structure of a corporate purpose. The new regulatory context seems to move away from an expensive understanding of stakeholder governance and towards a more recalibrated model in which stakeholders' involvement must be effective but also proportionate and manageable. The third point concerns the director's duties. This is one of the most important corporate law issues raised by the S.E.E.D and by the omnibus reforms. The question is whether sustainability obligation change the duties of directors, and more generally, the way in which corporate management must be exercised. Directors are not transformed into public authorities responsible for solving global environmental or social problems. And the pursuit of sustainability does not replace the pursuit of corporate interest. What changes is the procedure through which managerial discretion is exercised. Sustainability enters in the corporate governance as a matter of risk management, internal organization, information flows, monitoring duties, and decision-making procedures. Directors are required to take into account human rights and environmental impacts as part of corporate governance system. They may be required to allocate resources to prevent and mitigate these adverse impacts, and they may have to revise internal policies, adopted code of conduct, approve action plans, and monitor the effectiveness of those measures. However, Any assessment of directors' liability must remain connected to what the directors of the lead company can actually control along the supply chain. In other words, the directors cannot be held responsible for every adverse impact occurring within complex global supply chains. Their liability should be assessed in relation to what they could reasonably identify, prevent, monitor, and address, having regard to their actual position, influence, and available means. This is why these obligations remain largely procedural ones. They do not impose a guarantee that the adverse impacts will never occur. They require companies to adopt appropriate measures proportionate to the severity and likelihood of the risk, but also to the company's actual ability to exercise the control or influence over the relevant business relationship. This is also why the S.E.E.D can be understood as introducing a form of procedural accountability. The focus is on the quality of the decision-making process. From this perspective, the Omnibus package does not remove sustainable corporate governance. Rather, it reshapes it. It reinforces the idea that sustainability must be integrated into corporate management, but in a way that remains compatible with competitiveness, proportionality, and regulatory feasibility. The first point concerns the contractual mechanism along the supply chain. One of the most interesting aspects of the S.E.E.D is that the sustainability obligations are not implemented only through the public enforcement or internal corporate procedures. They are also transmitted through the contracts. The directive requires companies to obtain contractual assurances from their direct business partners concerning the compliance with the code of conduct and, where necessary, preventive and corrective action plans. These contractual assurances may then be extended further along the supply chain through a cascading mechanism. This means that sustainability obligations are translated in contractual clauses, monitoring duties, audit mechanism, compliance requirements, and in some cases, termination of business relationships. This contractual dimension is extremely important. On one hand, it allows sustainability standards to travel along a complex supply chain, and large companies can use this contractual power to influence the behavior of their business partner, including suppliers and subcontractors. On the other hand, the mechanism can also create some risks. There is the risk that the large companies simply transfer the burden of compliance to small business partner. And there is also the risk that sustainability becomes a matter of standard clauses, formal declaration, and box ticking, rather than a real process of risk prevention and responsible governance. This is why the S.E.E.D also required companies to support the SMEs where compliance with the due diligence requirements could compromise their economic sustainability. The contractual extension of sustainability obligations must not become a way of externalizing cost onto weaker actors along the supply chain. Here again, the omnibus reforms show that the European legislator is increased aware of the economic effect of sustainability regulation. The question is not whether sustainability should enter in the contractual relationship. It clearly does. The real question is how sustainability obligation can be implemented through the contracts in an effective but also a proportionate way. In conclusion, the recent reforms reveal a structural tension within contemporary EU law, EU corporate sustainability law. On the one hand, EU law continues to pursue ambitious environmental and human rights objective, and sustainability remains central concerns of the European corporate regulation. But on the other hand, competitiveness has become increasingly prominent. The most important novelty is not simplification. As such, simplification is normal in any mature legal system. The real novelty lies in the changing hierarchy between sustainability and competitiveness. For many years, sustainability was presented as a condition for long-term competitiveness. After the omnibus package, competitiveness appears as the framework within which sustainability obligation must be designed, assessed, and limited. This does not mean that sustainable corporate governance is over. Rather, it means that sustainable corporate governance is entering in a new phase. It's less focused on the transforming the corporation itself, and more focused on the redefined procedures through which corporate decisions are made. In this sense, the current trajectory of the sustainability law appears directed to redefine the procedural and organizational boundaries within which the managerial description and supply chain governance are really exercised. The corporation remains profit-oriented, but the way in which profit-oriented activity is organized, monitored, and justified is really changing. This, I believe, is the real reshaping of the sustainable corporate governance after the EU omnibus package. Thank you very much for your attention.
Thank you very much, Paola. I think that the topic of your presentation brings us directly to fundamental tension of the current debate, that simplification is not a merely a technical question, operation. It is a redistribution of responsibility, risk, and sustainability. And redistribution of sustainability is something that we have to think, because to impose sustainability to an enterprise, it does not mean that this sustainability will be redistributed along the value. So I give the floor to the second speaker, which is Miriam De Lucia from Federico II University. Federico the Second University. I said it in Portuguese.
Thank you. Good morning to everyone. Firstly, I would like to express my thanks for the committee that accepted my proposal. And the title of my research is Corporate Sustainability Due Diligence between Regulatory Simplification and Worker Protection, the Reduced Role of Responsible Disengagement. In my speech, I would like to analyze the changes that affected a specific profile of the due diligence directive following the final approval in 2026 of the second part of the omnibus package, and in particular of the directive number 2026/470. The reference is to the so-called responsible disengagement, understood as a whole series of mandatory requirements imposed on European companies to prevent the negative social impacts that a sudden termination of the relationship, the commercial relationship between parties might cause to the employees of partner companies or to the business that rely on the product or are affected by disruption in supply chains. My speech will be divided in 3 parts according to the time given. In the first part, I will give a schematic description of the mandatory sequence for implementing the concept of responsible disengagement as set out in the first approved version of the directive. Then I will highlight the main changes that were introduced in 2026. And in the last part, I will try to answer to the question made by Professor Barbato, and also to the question whether these recent simplification choices are compatible with the original objective of ensuring effective and widespread accountability along global value chain, or whether the current formulation risks excessively weakening the innovative scope of the directive. Well, about the first point, the mandatory sequences provided by the European legislator in 2024 was the following. Firstly, there was an obligation for companies to draw up an operation prevention plan or a corrective action plan in order to identify or mitigate potential or actual adverse impact on human rights and environment. Then, in the event of a confirmed breach of due diligence obligation, there followed the obligation to temporarily suspend the business relation with the possible implementation of remedial measures or a constructive dialogue in order to mitigate the negative impacts that had occurred. And finally, only as a last resort, there was in the original version of the directive the option of permanently terminating the business relationship. Well, from the analysis of these stages come out some interesting aspects that I would like to underline. Firstly, the breadth of the category of entities whose activities were to be scrutinized by leading companies in order to identify and assess the actual or potential adverse impacts caused by them. Then there was the obligation for companies to take all appropriate measures to prevent potential negative impacts and to stop actual negative impacts, including for sure the aforementioned prevention action plan, corrective action plan, but there is also the invitation to companies to work to obtain from each direct and indirect business partner contractual guarantees regarding the compliance with the code of conduct and the prevention action plan. Subsequently, only in cases where the text of the directive said in the original version is not possible, it's not reasonable to expect that such initiatives to be are successful, the directive provided as a last resort the obligation for company to refrain from entering into a new relationship or extending an existing relationship with a business partner in connection with whom or in whose supply chain the impact has arisen, and where is permitted by the law to proceed also with the definite termination of the business relationship for the activities in question, if the potential negative impact is serious. There is also, però, a safety mechanisms of this sequential system that is designed to protect workers employed through the value chain, that was the imposition on the company of the obligation before decide to temporarily suspend or terminate the relationship to consider whether the negative impacts of such suspension or termination could reasonably be expected to be more severe than the negative impact that could not have been successfully prevented or mitigated. And in such a case, the company should not be required to suspend or terminate the business relationship. Finally, it's important to only highlight the role of participation that in the original version of the directive was according to stakeholders in the formulation of company policies about due diligence obligation and in the definition of the way in which the responsible disengagement work. So this is the original version of the directive about due diligence, about responsible disengagement obligation. Going now to the second point of my speech, I would like to underline some amendments introduced in 2026. Firstly, there has been a decrease in the recipients of the directive obligation by increasing in the numerical threshold that identify them in order to reduce its application to small and medium-sized enterprises. Then there has been a revision of the procedures for identifying and assessing negative impacts, with the introduction of a strong limitation of such activities only to direct business partner and to the sector with the major level of risk and with potential more serious impacts. However, whereas with regard to indirect partners, the obligation to carry out a due diligence assessment has been introduced only in cases where the company has reliable information confirming the existence of ongoing violation or indicating a real present risk that such violation may occur. And the same obligation also applies when there is the evidence that the indirect nature of the relation with the supplier has been artificially constructed in order to circumvent the application of legislation and conceal a lawful conduct. But the major change made in 2026 regard Article 10 and 11 of the directive by removing from the mandatory sequence of responsible disengagement that I described, the provision requiring the termination of the relationship, the definite termination of the relationship with the business partner as a last resort, and replacing it with the only obligation to suspend the contract or the business relationship. However, the safety mechanism aforementioned is unchanged. And finally, there is also a scaling back of both the concept and the definition and the role attributed to stakeholders through the process of implementing the due diligence framework. And the new framework provides for a more targeted engagement, limited to relevant stakeholders and confined to specific stages of the process of due diligence. So to go to the conclusion, to sum up, describe the main changes that have affected the responsible disengagement. It is important to take a moment to think about what the consequences could be on the entire system of implementation of due diligence obligations. Firstly, I would like to underline that the legislator's action in 2026 is a part of the list of those interventions aimed at strengthening the European market and relaunching its productivity and innovation, which are in indication provided by the Draghi report. So these actions have been described as a simplification and bureaucracy reduction action. But despite that, these changes have been criticized from academic world, have been criticized from organization and expert groups of the sectors, because the main cause of these criticize is the overall implementation of a deregulation of due diligence and the restriction of its scope only to direct business partner. The feared consequences of that are, on the one hand, the risk of weakening corporate accountability, as said the Professoressa Barbato, regarding human rights and environmental protection, and on the other hand, the loss of European oversight capacity to see over those companies, indirect suppliers, operating in areas where environmental abuses or human rights violation occur most frequently. So the omnibus package has been considered by some as a dangerous step backwards from those hard-won principles and rules of corporate social responsibility, but for others, despite this objective narrowing and reduction of its scope, the progress that the due diligence directive has set in motion from 2024 regarding social and environmental rights can not longer be halted. So in this regard, I think also that as the Professor Pizzoferato said yesterday, that the European companies themselves play an important role thanks to their voluntary application of due diligence obligation, driven by the need to protect themselves from the economic consequences arising both from form of cutthroat competition and from reputational damage caused by negative events affecting workers or environmental, and by the wish to be in a position to enjoy the benefits of a responsible conduct. Thank you for your attention.
Thank you very much, Miriam. The question of responsible disengagement rises, in my view, one of the most difficult dilemmas in the entire architecture of the due diligence. Ending a problematic business relationship may reduce a company's exposure to risk, but it does not necessarily eliminate the risk itself. In some cases, it may simply transfer that risk elsewhere, leaving workers in the even more vulnerable position. This brings me to perhaps a provocative question: can responsible disengagement in some circumstances become a form of responsible abandonment? Because the company leaves the business relationship, but the workers remain exactly where they were, sometimes in a very worse situation. This issue, therefore, is not only when to disengage, but also what actually happens after disengagement. And the challenge, in my view, is to avoid both extremes. Disengagement as a purely formal strategy for existing responsibility, and on the other hand, an unrealistic obligation to maintain a business relationship indefinitely. The central question remains: who bears the concrete consequences of the decision of disengage? And now the floor, I give the floor to the third speaker, that is Antonio Capasso from University Mercatori.
Okay, so. One moment. Non va avanti e dietro. No. Se provo qua. Ok. Beh, te lo dico a te magari. Ah, va. Ok. Ok. Okay. Good morning, everyone. I'm Antonio Capasso. I'm a PhD student at this university, and thank you so much for the organization of this conference to Professor Mocella and the other professor, and thank you for Professor Barbato for the direction of this panel. My topic is, to clarify, is a first analysis of this team, and I have more questions than answer in this document, but the topic is a breach of supply chain due diligence obligation, civil and administrative liability and the transposition into Italian law. Okay. The context is a new architecture of the liability, the directive CS3D, revised by the omnibus package, and has approfondire reshaped the obligation of European companies on supply chain due diligence and extending the liability along the entire production chain. What was once a voluntary reputational commitment is turning into a hard law system of accountability anchored in a commercial and corporate law. The question of this paper is, how do these new forms of liability, civil, administrative, and in some system also criminal, actually fit within the categories of national, private, and corporate law? The Italian transposition is the testing ground. And a moving target, we have in this paper a moving target, the omnibus reset. On 18 March 2026, the Omnibus First Directive entered in force and recasting the CS3D before a single member state had transposed it. The duty now reaches only the largest group, roughly 6,000 companies with at least 5,000 employers and 1.5 billion in net worldwide turnover. To change, go to the heart of the liability. The harmonized civil liability regime of Article 29, paragraph 1, is deleted, returning compensation to national law, and the expression no less than 5% penalty floor of Article 27 becomes an harmonizing ceiling of 3% of net worldwide turnover. The second change is the Article 22 duty to adopt a climate transition plan is removed. An application is aligned, an application of this directive is aligned on a single date, July 2029. And by dismantling the European Union regime, the omnibus does not soften this paper question, but sharpen it. National private law is no longer merely the testing round, but the governing law. And the civil liability is in this directive a clause in search of, I think, because Article 29 of the CS3D require member states to ensure that company answer for damage caused to natural or legal person, where they breach their duty to adopt and implement a due diligence plan. This clause does not slot neatly into national tort system. In Italy, the Article 24.3 of the Civil Code, built on the Aquilian fault by Roman law, calls for an evolutionary reading informed by the precautionary principle and the new supervisory duty of European law. Can a general clause of neminem letter absorb a duty that is a procedural, organizational, and forward-looking, or does it strain the very notion of fault? Is one of the many questions of this paper. After the directive omnibus, Article 29 no longer supplies an autonomous European Union case of action. A breach grounds civil liability only where and as national tort law allows. In Italy through the Article 24.3. What survived is a floor, not a regime. Article 29, paragraph 2, preserve a right to full compensation without punitive or multiple damage, while Article 29, paragraph 4, confirm the adherence to industry schemes or third-party certification, does not shield a company from liability under national law. The deletion, Article 29, paragraph 7, strips the regime of its overriding mandatory character, returning the cross-border claim to the ordinary conflict of law rules of the law, second regulation. And the evolutionary reading for Article 24.3 must now carry the weight once shared with the European Union law. Is the Aquilian clause equal to the task, or does the burden expose these limits? And after civil liability, I have analyzed the administrative liability in the CSRD. Are two regimes or one system? The Article 27 empowers national authorities to impose pecuniary sanction calculated on the company's global net turnover with a maximum threshold of no less than 5%. In Italy, transposing this sanctioning logic means confronting legislative decree law 231/2001, the existing regime of entity liability arising from offenses, and its expanded catalog of predicate offenses covering environmental harm and labor exploitation. Is current coordination between the two regimes achievable, or are we heading toward a problematic overlap? And the third part of this extended abstract is focused on the due diligence like a duty of the board. A further question concerns the corporate governance. Read against the duty of director and the Court of Cassation case law on managerial liability may a breach of the due diligence plan amount to a failure of the board's fiduciary duties. If so, it's called ground liability action brought by the company or by its creditor. turning a sustainability obligation into a matter of internal corporate accountability. We have the timeline, the transposition timeline, and Italy is a very testing ground. The calendar is fixed, even as the substance is contested. The CS3D entered in force in July 2024 and was recast by the Omnibus Directive on March 2026. By July 2027, the Commission must issue its first guidelines, including model contractual clauses. Member States, Italy included, must transpose by July 2028. Scope companies must comply from July 2029 with the annual website due diligence statement for financial years beginning. In conclusion, the three years remain to decide how the duty is absorbed by Article 24.3 to the Civil Code, by the entity liability system of Legislative Decree 2001, and by director duties under this article of like the Italian Civil Code. I think that the directive sets the destination, but it is for Italian legislation to chart the course. And we have, for all its ambition, the liability system outlined by the S.E.E.D leaves notable gray areas that risk undermining its effectiveness. Fragmentation of national transposition across member states, uncertainty surrounding causation in transnational context, weakness of access to justice mechanism for remote victims. These are the questions that the future legal scholarship and case law are now urgently called to address. I have three conclusions in this short paper. The S.E.E.D marks a significant step forward from the voluntarist approach of the past. Due diligence is no longer a matter of corporate goodwill, but a legal accountability. Its effectiveness will be decided at the level of national transposition. Italy must reconcile it with tort law, the 321 system and company law without losing coherence, and the promise of directive depend on closing the gaps in causation and the access to the justice that remain open today. And thank you for your kind attention.
Antonio, então, I think that perhaps the real challenge of transposition is not simply where to place the new obligations in the Italian legal system, but how to build a coherent architecture of responsibility. Otherwise, we risk having many possible routes to liability, but not clear and effective path for victims seeking remedy. And now the floor is for the fourth speaker, that is Daniele Allega from
Yes, you read it right.
Catorum.
Yes, you read it right. I don't know if you can see me nor hear me. Can you? Yes, I was pinned. Thank you. I can also see the room. And I would like to share some slides if you are able to see them. Let's see. So as background, it's going to be desktop 1. And I'm going to share it. Oh, I need to log out and log in back. I need to quit and reopen the app. So I'll be 30 seconds away. I'll come back in a minute.
Maybe we can pass the floor to the other speaker, and when he that's because it's...
Here I am again.
Yeah.
Okay. And let's see if I'm able to share my slides right now. Yes. Screen. That's going to be script 1. No. Content only. There you go. Now you should be able to see me already. Yeah, I am also able to see you, more or less. Can you hear me and see me correctly?
Mm-hmm.
Well, thank you. Thank you for the floor then. I'm raising my volume over here. Thank you for the floor here. And my questions are actually stemming from the ones I heard before in this discussion, and especially in this panel, but effectively add another one. Well, let's really hypothesize for a moment that the directive is applied correctly, that the CS... I cannot hear you. I can hear you lagging. Okay, you do hear me. Nice. So let's hypothesize for a moment that the CS3D is applied correctly. And at least formally, we have a system that ensures that the formal legal aspect of it is nevertheless applied. Yet we incur in another question that doesn't really seem to me, is that it has been asked about, really not that I read of, and it concerns its contestability. And that contestability stems from an uncertainty that must be preserved whenever we are in a legal field, and that eventually we must keep asking ourselves in terms of the formality of it on one side and the effectiveness and the practical effectiveness, so quite the opposite of a formality, on the other. So if I do swipe my slides, you do see them changing, right? My slides have changed. You do see them? Yeah. Yes, you do, I think. I'm on my second slide. Yes, okay. You do see my slide changing. Okay. I hope so. Nice. So the basis is the reshaping that the CS3D actually provided. The omnibus, yes, lowered the bar for many of the requirements, and in fact, it heightened the requirements in terms of its scope. So only bigger companies now are required to go through that due diligence process. Yet on the other hand, actually, it forced those companies to not only express their involvement with the due diligence in terms of double materiality and the formal requirements that really come into effect with the omnibus package. I do not think, and I do not hold the belief that the omnibus package had only the purpose of effectively restricting the scope of the directives, but rather to try to save what was salvageable in a way, and try to apply it for what it could be applied to, at least in the scope that was given itself. So we really have to see these as pillars in a way. So those are the pillars, the non-juridical pillars that we actually try to document. And whenever we try to uphold the law and to respect the law and to apply the law of our clients to our clients, that is actually what we may be looking at in general. But what about the effective responsibility of it? Because if you think about it, we created for the moment a really hollow structure. So we have a compliance, yes, but often the actual reality of it is that it is often degrading into a procedural formalism rather than the effective responsibility. And these obligations that we are studying do not, or really should not, operate in the abstract. And we have a stack that we can actually design and apply it to our clients, to a company, to a compliance object, to effectively ensure that those obligations are met. And that met is with regard to the effective responsibility of it, not just the formality. But again, if you think about it in your real practice, in your common practice, you're ticking a box. And that is a problem I am trying to address. So on one hand, you had this hope and this real ambition to have a lens. And that lens should be a glass lens that effectively filters and shapes the color and shapes every problem that comes into it into effective guarantees, and in terms of contractual law, contractual assurances, for example, for third-party providers, that all of the problems that the CS3D is trying to effectively tackle are met, or at least challenged. But that lens, at the moment, is not letting pass through anything. It is not filtering anything. It just effectively posing as a shield. You hear me? I do hear noises sometimes. Yeah, effectively poses as a shield, and yes, it denies that coercion, child labor, forced labor, or retaliation leads to, just to mention labor law problems, because really those are the most effective one that we can actually see. Instead of actually putting them into the course of the due diligence compartment, what happens is that they're reflected away. So a company, whenever it's faced with the decision, what do? Do you comply with the CS3D or do you not comply? When they want to actually comply, the effect that we provided, the effect that we're having is that that company just chooses not to pursue that provider, that third-party provider. I don't know, let's say that you produce pens. The part of these pens are actually provided by very much different companies, and those companies may not be in the European Union at all. On the other hand, quite the opposite, you may find that each part of this pen is made of in a so-called third world. But what do? Instead of actually try to ensure between, I would say, the strings of the contracts and the assurances that you can actually ask that provider, it just reflected. And you, on one hand, say, I could have not known that, and that's pretty much a deny of any responsibility whatsoever. Or on the other side, you try to say, well, you know what, this is not clear enough for me. I'm just getting out of this deal. So this comes to a problem, because if you think about it, what we describe is pretty much a filter, a pretty opaque filter. What should be a lens, so through which lights pass, and by light, I mean accountability and the effective measurability of the company's involvement in the, well, I will use the ESG as metrics here. So environment, social, and governance, for whoever doesn't know, but I am sure everybody in this room, all of the 10 of us pretty much do understand that framing. We do have a dilution of the responsibility and effectively a funneling. So what do? Well, before you even do anything, you try to filter with a tool, an automated tool, whether that company is great or not. So that company may provide, let's stick with the example of the pen. I will ask that Thailandese company, that Thai company, where and how is your pen and your material sourced? How are they sourced and how are they worked on? Do you respect human rights? So the first thing that they will do is they will provide me with a ton of documentation. What will I do with that documentation? Of course, I'm going to screen that documentation with an automated tool. And that tool involves a risk assessment function. And that is going to be a first filter, if you think about it, because that's obviously what is going to happen. Then whenever that screen is actually done, you will try to report on that findings. I will try to talk to the manager, and eventually you will score all of the suppliers and all of the providers that you encountered. And yet, in all that procedure, let's say the workers, really anyone here, is not really evaluated. So in the case of human rights, those are out of the picture. You don't really think about that, and you really don't, they're not provided in any parts of the directives, and they're not provided in any part of the law, because they actually are enshrined in their control by a formal procedure. So you have to list some checks, you have to control them. And yes, I do understand that the law cannot be omnipresent, but what if we can actually design a legal system that provides for it? We do have the tools. For example, we could implement some kind of employee reporting. Yes, I do understand that trade unions and labor unions are not a common thing in a third world country. Yet we still have ways as a European country, as a European last resource supplier, last resource buyer, we do actually have the possibility to ask our supplier or our provider, for example, to administer some questionnaires. That is not unheard of, and that is not really that complicated. Those questionnaires, yes, could be made by an AI, and yes, could be answered by the colleagues. I know there is a problem in whether that questioning and that surveys will be accounted for really and will be transparent, but at least we are trying. And again, we have AI tools that could actually look into that and ask and provide what I would say a form of reliability scoring. We're not talking about just a formality here. This is turning the law into something really useful. And again, I underlined just in a couple of slides back how much, yes, we have a reliability problem. Yes, we can score, and you say, I understand the claim that, yeah, in the third world country, let's say in Myanmar or Burma or Thai or whatever, you have no trade unions, you have no reliability of the surveys whatsoever. And I'm saying the surveys just because it's the really easier thing that we could understand here. But yet, even though you don't have any check system, what you can do is contest it. Well, okay, you don't have a reliability check because there are no trade unions in Thailand. No effective, I don't know about Thailand in the specific case, but I'm just making one. And what about the Italian ones? What about the European Union ones? They could contest the same method. I do understand, again, they do not have the interest about it, but as a design for how a legal system could work, we have an answer here. We have a possibility. And so we arrived to a pretty much effective divide. For the moment, we have a legal system that really is centered about formal compliance. And everything really revolves about how much can you prove. This is how actually law was born since the Roman Republic times. Yet, again, we have new technological tools that may actually allow us to change this perspective from audits and formalism to redress as a concept. Yes, static dashboard and conflict are cool whenever you tweet them and you say, well, no, what? Look at this. These are my results in terms of ESG human rights, but yet you don't have feedback loops. You don't have open systems. So that ends there. Whenever a company says, we achieved our ESG goals, this big four company certified that. Oh, wonderful. And that's it. That pretty much stops there. There is a filtering. I already described it, whilst we could actually actively record everything and step up from passive subjects to active challengers. So the Italian trade union for Ferrari, for example, or whatever company is Italian, the European Union-based trade union could contest and challenge every part of the process. And that could be useful because if you think about it, it is in their interest to underscore and put out to light and discover every humanitarian and human right problem that a company generates in a third world country, for example, because they could invite the company to relocate some of the activities, some of the industrial activities into the European Union, where there will be more European Union workers and then more European Union trade union members. So yes, the trade unions do actually have an interest to do this. And the liability function here is the result of everything I said before. So at the moment, it's just a shield for corporations to say, yeah, you know, we did our audits, we're right, this is it, we're at it. But yet, again, if you don't enable the communication between your trade unions and, I'm making a case for labor law here because it's the simpler to really understand and figure out, but this could be also made for the metal and the environmental problems that the extraction and mining of metals of this pen could actually have. So this clearly could have been, well, yes, this is the problem, thank you, that was all, but no. I tried to whenever I identify a problem, to propose a solution for it. And this is a contestability protocol. Yes, there are plenty of normative criteria. I do understand the European Union law is full of it, and we should not want to add some more principles without articles into the law, and we should not add more intra parentheses wordings, and eventually the preface of the European Union Laws Act, both regulation and directives, are pretty much verbose. So I do understand we already are hitting a point here. But again, if we just state these five are pretty much all we need to at least frame what we must do into the law. That is not really that little. And we can actually understand two pillars of it, or try to focus them. The local factory is the one that may be in a third world country in this example, and you put it through different steps of verification. So one actually doing white label supply, white label demand, and to actual proceeding of it, while the other goes into, again, the trade union, if we are talking about human rights. So what about the environmental associations and stakeholders on the other? Yes, they try to do that, but since they're not obliged by the law to provide any documentation to these companies, that is pretty much voluntary. That doesn't work. What you could do is to actually exploit this association by putting them into the legal framework. And I'm not really sure that they would do a worse job than auditing companies or big four companies, because at the moment they have an oligopoly on that. And wherever you put everything into the verification, the famous and lovely corporate dashboard that we have at the end actually assumes everything that was understood before. You got everything in one place. At that point, yes, I would love to see a dashboard for it. And on the other hand, you should doubt everything of that dashboard. That's the second pillar. That's the uncertainty. Once you doubt everything and you don't have data blind spots, you have recorded that uncertainty. I'm coming towards the conclusions here, and yes, the general concept is that stakeholders must have direct pathways, and by direct pathways, by that direct, I mean legal provided pathways. Direct meaning provided by the law, not just by some understandable marketing accountancy and marketing, I would say, preoccupation. So whenever red flags are raised regarding coercion or retaliation risks, the system must empower stakeholders to challenge the corporate narrative. Why? Because they have the official documentation. And why they do have the official documentation? Yeah, because it's provided. I do understand that at the moment we are requiring everything that is pretty much non-material reporting to be online and on websites. But again, those are public and those are not really effective, and those will never be, because you have two different instances. The one to sell everything to the market, and that is a pretty well understood problem that ESG is becoming for some companies a marketing tool. But on the other hand, those companies, that WWF, that trade union, that whatever company association of stakeholders can indeed have an effectiveness. At the moment, yes, we do have technical tools, and I will not stress this enough. They have been used as a shield. That's it. That is what these tools are made of, and that is what these tools are designed for. I know it, I worked with them, and I do understand the problem. Yet, is the law that enshrines that system and that logic at the moment the way it is in the concept itself. And what we're trying to achieve, finally, is a closed loop system, because every time, again, the example with the iron in that pen, in this pen, every time I have UF challenging every decision because it does have legally privileged information. That is not something you find on the website, and that's something you are paid for just as an auditing company, but you have a different interest because you have your own narrative and your own goals and your own stakeholder direction. You create a closed loop. yes, those company risk becoming an other, I would say, auditing loop instead of a closed loop. But I don't think they will. I don't think they will. I don't think they won't. And that is because simply they have a different interest. And that contestability for them is an economic value. So they will never lose it. They will never get an hold of it and just give it away, because that's part of the reason of business. If we can call the WWF a business, but you got it. And again, this actually stems from my previous research in more specifically AI governance, but I think it can be applied to here, because if you think about it, governing AI and setting rules for companies when dealing with AI actually gives you a set of rules that is really useful. And we wrote some pieces on this, some papers, and you can check them out. Everything is online, and you can find it on GitHub pages. And also they are published with reviews and ESSN numbers. But if you think about it, there can be some points of connection. And yes, there can actually be some interesting developments between the two, because once you set rules for AI, everyone is going to use them, or at least try to use them. And if that is the case, probably those rules will be hereditated, will be had by the company more in general, because they're already there and they're already known. I will leave you with the concept that I'm trying to understand, that the future of due diligence is not really depending on the former existence of monitoring procedures. We already have them. They don't seem to me that they are working, but rather on whether these procedures remain open to challenge by the person whose rights they are meant to protect. And the only way for a person in Thailand to do that is to have a European friend. That is the solution of it. That is my hypothesis. And yes, I do understand this dilutes the problem, because a company could change its location. And if you do not track it very well, you could have a problem, because you got no points of reference there. You just cannot send journalists in Thailand and go ask them questions. But at some point, yes, we will need to establish connections, because this is not a continental issue anymore. Global value chains won't stop. Yes, relocation and friendshoring are a thing, but they're not nearly enough. And this isn't just Nike stock price falling in the last 3 years because of this. It's not just a thing of marketing. It's a problem of understanding how do we want to make EU law really global, as we try to do. And we tried actually in very much important acts, such as the GDPR or the AI Act more recently, to enshrine a principle that EU laws applies basically in every part of the world. The way we do it is through a network of stakeholders and actually systems that reports to us, and not just formalities that we try to apply here in Europe. And yes, if the European part is done, we checked our Excel file, every tick box has been answered to, and yes, this is it. No, that's not the solution for me, and I hope I presented to you what I believe is a valuable alternative. Thank you very much for listening to me, and if you have any questions, I'm here. I saw you clapping, but I'm not hearing you. I'm sorry.
Okay, thank you, Daniele. I found interesting the idea of contestability because it highlights a fundamental limitation of due diligence system, that is the multiplication of audit certifications and technological tool does not necessarily guarantee better protection of rights. On the contrary, it deals with corporate responsibility. The real challenge, therefore, is to transform workers, trade unions, and affected communities from passive recipient of this protection into active actors capable of influencing risk assessment, prevention, and remedy processes. And now the floor goes to the last but not least speaker, that is Pia De Petris from University of Milan.
Okay. Thank you, Professor Barbato. Good morning, everyone. And I sincerely thank the Professor Mocella and all organizers for this opportunity. It's a great honor for me to be here. One moment that I can present my slide. Okay. So my paper aims to offer a systematic reflection on the effectiveness of legal instrument protecting labor in global value chains. In particular, it analyzed whether the 2024 Corporate Sustainability Due Diligence Directive still retains, in the light of Omnibus package, a genuine capacity to improve working conditions. The analysis would both cover traditional supply chain, but also new digital outsourcing chains, which are among the most critical and least regulated areas of transnational labor law. The guiding thread of my analysis is the principle of effectiveness, assesses through the capacity of a due diligence obligation to improve working conditions, prevent violation of fundamental and labor rights, and ensure justability of these rights. So, first of all, to understand the innovative scope of the Corporate Sustainability Due Diligence Directive, it's important to note that the voluntary paradigm of corporate social responsibility has demonstrated structural limits that have proven difficult to overcome. So, in fact, for 2 decades, soft law instruments such as Corporate Code of Conduct, the OECD guidelines, or also the UN guideline principle on business and human rights, but also social auditing initiatives, have in their fragmentation failed to ensure effective control over global value chains and fair working conditions. So the respect for fundamental labor rights has mostly relied on the goodwill of the lead companies without the binding mechanism of verification and accountability. Against this backdrop, the Due Diligence Directive marks a shift from voluntary standards and paradigm to legally binding extraterritorial rules. In particular, the effectiveness of the due diligence under the directive is based on 3 pillars, which should be briefly, I hope, briefly recalled. First, we have due diligence obligation across the entire chain of activities. The directive brings business partner, and this is important, within the definition of a chain of activities, according to the Article 3 of the directive. So companies must identify, prevent, and address negative impacts on human and labor rights, extending in this way responsibility beyond corporate boundaries to subsidiaries and business partners. The second pillar is the civil liability. Before the colleague Morris, but also Antonio Capasso remind us that the directive introduces a compensatory regime for breaches of the due diligence, allowing victims to bring claims against the parent companies. And this increase legal accountability and has a preventive and deterrent effect. Finally, we have the third pillar, collective participation. The directive establishes obligation of prior consultation with worker representatives in the design and in the implementation phases of the due diligence plans. And this provision constitutes a significant innovation compared with early regulatory models. In other words, the labor protection is not longer ensured only through public employment enforcement, but also supported by collective instruments that help trade union monitor compliance and enforce worker rights. So while recognizing these advances of the directive, which reinforce effectiveness of the due diligence to improve working conditions, it should be noted that the directive has undergone a complex political and legislative process that has in part reduced the scope of its protection. In fact, under the Omnibus Directive, the simplification process has introduced amendments that go beyond technical or procedural changes. In fact, in addition to delaying some obligations through the so-called Stop the Clock Directive, Omnibus Package also modified the substance of some due diligence rules, reducing the effectiveness of the protection system established by the Due Diligence Directive. In particular, with regard to personal scope, the omnibus packages has increased the size threshold for the directive applicability, excluding a significant number of companies that should originally have fallen within its scope. The goal is to reduce regulatory burdens, but the practical effect is remove medium-sized companies from the directive scope, even though they often play a key intermediary role in a supply chain between large firms and lower-tier suppliers. With regard instead the material scope, the amendments have reduced the intensity of verification obligation concerning the more remote tiers of the chain of the activities. In particular, the distinction between established and direct business partners with the stricter obligation for the latter risks creating gaps in protection where violation of fundamental labor rights are most common and severe. In particular, critical is the reduction of information and disclosure obligation, because the capacity to monitor, prevent, and address labor rights violation is directly proportional to the availability of accurate information about the structure of the supply chain, especially for the collective actor. So, in my opinion, the relaxation of obligation to collect, retain, and communicate this information is risks to undermining the preventive function of the due diligence, thereby eroding the effectiveness of protection. And this problem is in particular evident in digital supply chains, characterized by the use of remote work, for example, on digital platform, because in this context, organizational opacity is structural. The end client doesn't know and sometimes is not in the position to know the identity, the geographical location, the contractual and also the working condition, of course, of the workers that work on digital platforms. So algorithmic intermediation makes employment relationship less visible and increase fragmentation in a chain that is already difficult to map. So in this context, the reduction of information obligation risks undermining transparency, which is essential for detecting violation and activating remedies. Another problem in this context is also the lack of coordination with the Directive 2831 of 2024 on platform work, which recognize transparency obligation for platforms that operate in Europe. But I don't want to go over time, and I have to skip this issue, also because I am the last speaker, so I feel the responsibility of your lunch. So turning to the conclusion. Briefly, quickly. So the due diligence directive represents a qualitative mechanism and collective tool that are really important. It introduces a extraterritorial binding obligation, accountability mechanism, and collective tool. However, omnibus package has also partly mitigated this instrument by reducing their scope, softening obligations, and weakening information. Transparency duty also, and civil liability rules also. So in my view, these risks undermining the preventive function of due diligence that, as says before by Professor Giovannone, is the key point, the central point to enhance protection on working condition through due diligence. So there are limits such as a prohibition on gold planting under Article 29 that reduce member states' regulatory spaces of prevention. Then the limited resources of workers' representative and stakeholders also reduce enforcement capacity. And anyway, significant protection gaps also remain, particularly in digital value chains that, but also in the case where companies are based outside the European Union, where extraterritorial jurisdiction faces structural limits. So the result is that the directive, due diligence directive, risks being least effective where protection is most needed. In the lowest and most opaque tiers of global value chains, without hard preventive safeguards. So effective implementation of the due diligence maybe will therefore depend on member state, supervisory authorities, and especially collective actors making full use of the monitoring and enforcement tools that remain available under the directive also after the omnibus package. So many thanks for the attention, and I hope to make the time.
Thank you very much for your intervention. I found the focus of effectiveness particularly important because it shows that exists a legal framework that is not sufficient, it's not enough. The intervention clearly highlights the tension between the advances introduced by the S.E.E.D and the weakening effect of the omnibus package. Actually, and I think that we extended a lot. We had a nice panel very rich. I want to congratulate all you and say that I hope that all these discussions can reach who really can do something to improve the condition of the workers, because this is our purpose, and we have to go in this in this way. So I think we can close this panel. Thanks a lot, Mercatorum, Marco Mocella, for this possibility that we had, and say that we have a very rich, we have a lot of arguments and lots of brains here to think our labor law. So let's go.
If you follow me, we have a pizza lunch for everyone.
Sono stati veramente interessanti gli interventi, complimenti, differenti.
Temiamo che ci fosse sovrapposizione, invece
Invece no, avete...
Io l'ho pensato all'inizio vedendo i titoli.
Differenti.
Forse parliamo tutti lo stesso.
No, invece no, vabbè, poi...
Vabbè, comunque... Bene.
So, good afternoon, everyone. Thanks to be with us also in this last part of the 2 days international seminar organized by the S.E.E.D chair, and I want to thank Professor Mocella for being our chair and all the colleagues of the labor law group that they always host me. I'm a professor of company law, and I'm really glad that I have the possibility to work with them as we do this exercise of interdisciplinarity. And sustainability, of course, is a field in which interdisciplinarity is essential across law subjects, but not just law subjects. And this afternoon, I'm going to be the moderator of a panel about case studies in corporate due diligence and supply chain liability. So we will see how the European Union directives are influencing third countries. I'm really honored to present relevant speakers from countries that are all outside of the European Union. Some countries are closer, like the UK, but it's still outside the European Union, and others like Turkey, Russia, Bangladesh, and China. So we will see the impact of our debate and a perspective that is different from our. I believe that all of us that we are passionate about sustainability, we study sustainability, we were a bit scared of the last steps of the EU legislator. I'm referring to the Omnibus directive that was discussed in the previous panel. So now we have the chance to see what the perspective from outside. Inside of the European Union, maybe we are doing some steps back, but we are still an example for other countries. Other countries look at us as a possibility to avoid violation of the human rights or the environment. Moderating, it's a rewarding and demanding task. As a person that has taught me a lot said once, there is a proportionality that it's inversal. On one side, my curiosity will require more time, but on the other side, as I will be the moderator, I need to be a little bit strict. So I remember to all the speakers that they have 15 minutes each. And at the end of the panel, we will have time for Q&As. So we can start with Burak Sonmet. He's a faculty member and a researcher at the Faculty of Law in Turkey. Tekir Dynamic Kemal University. I'm sorry.
Perfect.
Perfect, because you are flattering. I'm sure it's not perfect, but thank you. You will present a case that is linked to your country, to Turkey. It's a leading case about the Paris court concerning Yves Rocher Group and a subsidiary that is in your country. So about trade union rights, right? So the floor is yours. Thank you.
Thank you very much. Let me share my screen. Okay.
Right now, we don't see anything.
Yeah, sorry.
That will be enough, I mean, but more time for.
Yeah, I'm having a.
Or another way can be if you send your slides to our office and we can share the presentation for you. You should just tell us when we have to.
Yeah.
We already have your presentation? Ce l'abbiamo già? No. So you can send it.
I think it's okay now.
Ah, yes, it's okay.
Yeah.
Perfect.
Yeah. Sorry for the delay. Yes. Good afternoon, everyone. And first, I would like to start with thanking to the organizing committee and also the scientific committee, and also Mercatorium University for this event. And today I will be presenting on enforcing freedom of association beyond borders, focusing on transnational corporate liability for union busting in Turkey. And first, I would like to start with a little roadmap. So over the next 15 minutes, and I will guide you through this roadmap. First, we will start with the core paradox, globalized supply chains and localized labor rights. And after that, we will look at the limits of the domestic law in Turkey, especially on the matter of collective labor law and procedural hurdles for trade unions in Turkey. And after that, I will be focusing on the main issue, actually, the petrolist trade union ruling by the Paris court in this March. And finally, we will look ahead the directive era and conclude. So let's start with the first part. So while supply chains and capital across borders effortlessly, trade union rights remain strictly confined within national boundaries. Historically, this structure has diluted corporate accountability. Multinational companies often benefit from anti-union practices in supply countries while hiding the corporate veil. This brings us to the main question: can European mandatory due diligence legislation provide effective cross-border protection for trade union rights in non-EU supplier countries such as Turkey? Because while national labor laws provide statutory protections, the deterrence of domestic legal frameworks against multi-tiered multinational corporate structures remains limited. In manufacturing hubs like Turkey, procedural hurdles, heavy burdens of proof, and broader socio-political constraints often leave local trade union movements with restricted room for maneuver and without effective remedies. So if you look at the procedural hurdles for trade unions in Turkey, we must look briefly at the collective labor law system in Turkey. And also, to answer the question earlier, we need to understand the practical limits of domestic law. First, we must say that while freedom of association is a constitutional right, however, unions in Turkey face severe structural hurdles. It is because, first, collective bargaining system is structured at the sectoral level rather than the enterprise level or workplace level. This creates a massive burden because shifting the focus away from the grassroots organizing to simply chasing macro-level numerical targets, which brings me to the second point, which is the double majority threshold, which means that a union in Turkey to negotiate with the employer or employer associations a collective agreement, they first need to obtain double majority, which means that first they need to gain members or collect members at the sectoral level, at least 1% of the whole sector countrywide. Plus to that, also trade union need to have more than half of the workers, in other words, more than 50% of the workers in the workplace, so that they can enter negotiations with the employer or employer associations in order to conclude a collective labor agreement. And the last point is that we see strong state interventionism, such as frequent postponement of lawful strikes by the government. And also, plus these 3 points, beyond the legislation, we also need to look at the reality on the ground, because these 3 main structural pressures, union organizing in Turkey is frequently concluded in whispers and behind closed doors, which I mean unions actively avoid bold, visible actions so as not to attract employer hostility. Because if they make avoid moves, then they become a target by the employers. And then when we combine this constant fear of the retaliation with the sectoral membership threshold, the power dynamics of labor movement are fundamentally weakened. And furthermore, protective legal mechanisms exist mostly on the paper, because even if we have a discrimination compensation on the grounds of trade union membership, employer interference remains rampant, as we see also in this case that I will show in the next slide. Because when workers are dismissed for unionizing, also wrongful dismissal lawsuits takes long time and mostly years. Ultimately, this strips domestic legal framework of any real deterrence, leaving workers without an effective, timely remedy. So the outcome is the domestic legal framework often lack the deterrence required to prevent union busting effectively. So against this background, we had a decision in France affecting Turkish trade unions, so which can be called a slight shift in the paradigm. So according to this case, the case was decided under the duty of vigilance long before the directive was finalized and become effective, which dispute involved over 130 workers, which is the 30% of the workforce on that time, who were dismissed by the employer, Yves Rocher's Turkish subsidiary, Kozan Kozmetik, for simply joining the Petrolish trade union. So then, the French court found that the parent company failed to identify and mitigate specific risk of union busting in its vigilance plan, which is a requirement by the French law. So the failure constituted a compensable civil fault. So this is a significant precedent, especially for trade unions in Turkey. It establishes a direct liability link between a European parent entity and a local labor dispute abroad. Also, what makes this decision truly significant is how it overcame local jurisdictional barriers. Because French court classified the duty of vigilance of the company as an overriding mandatory provision under Rome II regulation, and because safeguarding human rights and also freedom of association in this manner was deemed crucial by the French state, the court bypassed Turkish tort rules that would normally apply and applied French law instead. And in essence, a single European domestic law successfully provided cross-border legal support to a vulnerable trade union movement in a non-EU state. So if we look ahead to the directive era, if a single national law could achieve this, we can also imagine the impact of a continent-wide framework. Of course, as also mentioned in the previous panels, there are questions and discussions in the implementation of the directive. But looking ahead to the next era, we are also witnessing a permanent transition from voluntary corporate social responsibility reporting to mandatory civil liability. In other words, the directive aims to standardize these due diligence obligations across the entire European Union. And most importantly, it imposes a legal duty on large companies to safeguard fundamental rights and also freedom of association throughout their supply chain, regardless of where the supplier factory is located. So I will also say that the directive will have a catalyst effect on third countries like Turkey. Also, if we take into account that Turkey is still a EU candidate country, so it also has an obligation to, in some point, hopefully, implement this directive also in the national law. The directive creates a top-down institutionalized pressure on employers, and European parent companies also will now be forced to enforce this labor compliance upon their global suppliers to avoid civil liability at home. This dynamic has the potential to empower local unions such as Petrolish Trade Union in Turkey, as we've seen in the case, expanding their room maneuver and also changing the power play between the social partners. Ultimately, this external pressure has the potential to structurally reshape the power dynamics of industrial relations in major non-EU manufacturing hubs. And to conclude, transnational due diligence mechanisms effectively bypass practical limitations and procedural hurdles of local labor jurisdictions. The Petrolish case showed us what is legally possible even without the directive. In this manner, the directive has the potential to take this further, transforming isolated national judicial tools into a systemic continent-wide shield for workers. And advancing corporate responsibility fundamentally means advancing human rights globally and holding companies accountable beyond borders. So thank you very much for your time and attention today.
Thank you so much for your clear presentation, for respecting the timing also, and for giving us a bit of hope. I believe that many presentations that we heard yesterday and today are full of good expectations. It's true that maybe the latest version of the directive, it's not so helpful from this point of view, but it's good that us as researcher and
citizens of the world, we try to interpret the discipline in this way. If the other speakers agree, I will do a small change because we have our speaker from Bangladesh, Sabir Hossain, who said that has a problem, and so I will ask him to do his presentation before the other. Sabir Hossain is a labor law expert, professional and lawyer specialized in labor rights. And his presentation is about living wages. That it's a topic that it's really interesting to me. I had the chance to study living wages with my colleague of labor law of this university. And if I'm not mistaken, you are going to talk about not just Bangladesh, but also Cambodia. So I'm more than curious to hear your presentation.
Okay, thank you. Am I audible?
Yes, we can hear you.
Okay, first of all, thank you very much for the opportunity. So today, as mentioned, today I'm gonna talk about the living wage context, and particularly I'm gonna share about the ACT model and how that can be a effective tools in terms of achieving living wages. So that's gonna be the main argument for my presentation. So in this presentation, I'm going to focus on the how ACT process works, and particularly its success in Cambodia and how the Cambodian garment sector is using it. And there are examples and agreements. So I'm going to talk about that, and at the end, I'm going to talk about that how that can be replicated in countries like Bangladesh. And the core argument would be that like the living wages need to be enforceable through industrial relation, and it cannot be achieved through compliance check. And I will try to connect the corporate due diligence with the practical wage setting models in the garments setting industry. Okay, so in terms of if we look at the due diligence directive and what actually the major challenges in terms of earning living wage, because the due diligence directives so far the way it has been adopted and being implemented, it hardly we see that like any ground level changes in terms of living wages. So what are the challenges in terms of that? The workers need to have a wage setting system and not only audit reports, and freedom of association is the key in terms of achieving that. And a responsible purchasing practice actually shapes what actually actually translate into real wages. Unless and until that can be achieved, that living wage cannot be ensured. Corporate responsibility must also be included in the pricing, sourcing, and bargaining power. So these are the like key background issues. And so in terms of due diligence directives, obviously it strengthens the human rights aspects, particularly the worker rights aspects in the supply chain, and but it does not alone automatically raises the wages. So that's the concern. And living wage requires institutions that can set the wages into practice, and collective bargaining and the tripartite wage setting fixing. These are the like two legitimate pathways by which the living wages can be ensured. So what ACT is and how it is connected to the wages and supply chains industrial relation. So as we say, the ACT is a global agreement, and it's an agreement between industrial global union and international brands and retailers. The ACT, as we say, action, collaborate, and transform, and it focuses on to transform the industry, particularly garments and leather industries. And it's a step-by-step approach to achieve the long-term sustainable garments and footwear industry. And it also have a global blueprint driving living wage and responsible purchasing practice in the industry. So it was jointly developed with industry all and some of the key brands who agreed to join it, and obviously it's strengthened the freedom of association, which is key to the due diligence obligations as well. And obviously, whenever a particular brand or retailer gets into this agreement, there's a binding agreement. It's a binding agreement which gives certain responsibilities and duties to the brand to ensure throughout its supply chain, particularly to the suppliers in whichever countries they're sourcing. So these are the certain brands, participants of ACT, and major brands like Inditex, H&M, PVH. So they are Primark, they're part of it. They have already signed this agreement. So what this does, what ACT does in the supply chain in terms of industrial relation, if we see, is that it's trying to ensure higher wages and resilient supply chain. And how it does it, we have already mentioned about through industrial relation at the sectoral level or at the factory level, and through binding agreements and improving purchasing practices. At the factory level, there can be collective bargaining agreements, and at the industry level or the national level, there can be tailored agreements. So how is ACT aiming to raise the wages and improve resilience in terms of bringing manufacturers? It brings manufacturers, trade unions, and brands together to develop a binding agreement, and as an industry approach for collective bargaining and wages. And it also affects the global purchasing practices in terms of leading to a higher wages. So let me just quickly move on to some of the examples. Okay, so how this global purchasing practice actually commitment works. So brand commits in terms of purchasing practices, including wages in item costs, and brand commits to fair terms of payment, and brand commits to better planning and forecasting. And brand also commits through these agreements and undertake responsibilities in terms of sourcing from a particular countries. And brands also commit to practice responsible exit strategies. So what happens is that, like I can give one example that, for example, the living wage, the minimum wage in countries like both Cambodia and Bangladesh, it's for the garments workers is around only 100 USD per month. And through this ACT process, what happened, I will again share in the Cambodian example that certain brands or retailers, they agreed, and they through that they increase the price of the products, and through that the factories who actually produce the products, they can actually increase the wages to a certain percentage, and that actually affect the real living wages. And particularly we have seen during COVID that like many brands without prior notice, suddenly they pull out their orders or those things. So ACT in this case also get that commitment that the brands and retailers will actually engage in a long-term engagement with the particular factories, so that the factories can actually invest not only expanding the factories or ensuring safety for the workers or better working condition, but also committing to better wages. So this is the Cambodian example, new model in the supply chain, industrial relation in Cambodia. So what we see is that in this, how this Cambodian agreement is structured. So the brand employers and the union groups are at the top, and here we have two separate layers, particularly at the collective bargaining level, at the factory level. It's between the employers, employers association and the trade unions. So they have agreements. And at the international level is the global brand and the industry all. So they have an agreement. It's a legally binding agreement. So what comes through this is that at factory level, collective bargainings are signed where the workers get a higher wages, and through the brands and industrial agreements. So it's a commitment and commitment to work together in those particular factories in certain countries. So this is how this total agreement works through from the international level to the country level. So overall, some overview of the CBA agreement of the Cambodia one. After that agreement, so each worker is getting $6 monthly increased wages at the factory level. So it's on the basic wages. So it actually has a effect on other like gross wages and all other benefits that worker gets. And it's only at the beginning. So eventually it will increase. And there are through this agreement, they have ensured special leave, skill developments, dispute resolution mechanism, and other benefits. And further advantage this agreement gets is that this is the first ever brand supported agreement, collective bargaining agreement in the supply chain. And also it gives opportunity, it gives an opportunity for the companies to show that highest levels of compliance with the international due diligence regulation, and it strengthens their reputation. If we move forward, so in terms of trade unions, so they are, particularly the Cambodian trade unions, they are pretty much positive about this agreement. And they have seen ground level changes, like particularly those factories, those are covered by this agreement, that workers are actually earning higher wages compared to other factories. And there has been some good quotes from the industry affiliates. So these are some of the quotes. It's a new deal for the quotes shared by the industry affiliates. So, and in terms of the binding agreement, so how it's just an overview is that it's mentioned about the country's sourcing volume, and it includes the factories. It's encouraged the factories to sign collective bargaining, and it integrates the labor cost into purchasing practices, and wages increase are fully reflected through that. And it also encourages skills and training funds through that agreement. And these are actually enforceable through binding international arbitration. In case a particular brand do not comply with this agreement, it can be taken to international arbitration. And monitoring through independent organization, it assures more effectiveness, and it directly includes buyers in the wage support structures in a binding way. So this is in short snapshot of the CBA. Like currently there is 13 global companies who have signed and agreed for this act process, and 8 factories have signed collective bargaining agreements, and approximately 10,000 workers are covered by these CBAs. And on average, $6 wage increased for the workers for each month, and 10 days additional maternity leave has been added for the Cambodia case, and 5 days paternity leave. Grievance mechanism has been introduced as a part of the CBA, and in total, there's a collective commitment on skill trainings for the workers. So this is why this model matters for Cambodia, because the brands commit not to move production because wage raise, so they will continue the support, and this agreement supports it, and it's legally binding. Enforcement can be used international arbitration that I have mentioned, and brand must actually help ring fencing through the labor cost. And what would be needed in terms of countries like Bangladesh is that like stronger freedom of association, like union push is really needed in terms of ensuring this sort of agreement and making sure more brands are committing to it. And dialogue among brands, employers, and unions is required, and responsible purchasing commitments. And wage cost builds into sourcing prices, and predicting sourcing, and no retaliation against the union. It's also important. And in terms of how this compliance can be transformed and through the industrial change. So obviously the corporate sustainable due diligence directives, it creates a pressure, but this act process shows how due diligence can support wage outcomes. And Cambodia is a proof of that model that can work. And Bangladesh can adopt this sort of model at a sectoral level, not only RMG, but also other sectors. And living wage needs institutional bargaining and buyers' responsibilities. So that was it. Thank you.
Thank you so much for your presentation and for sharing with us interesting experiences that are far from what we usually have the chance to see. And I believe that we can move forward to another third country from the European perspective. Now we talk about Russia with our guest Anthony Zilkin. We have him connected. Okay. Anthony, are you okay? Are you here? Perfect. Okay, now I also see you. Great.
Fantastic. Can you hear me?
Yes. You are a lecturer and PhD candidate at the School of International Law at the HSE University in Moscow. And you are going to analyze a case with us that it's about, in reality, another country, that it's Egypt, in a field that I believe it's really challenging because it's about agriculture and exploitation in agriculture. So the floor is yours.
Yes, thank you very much. And can you see my slides?
Yes.
Fantastic. So, good afternoon, dear colleagues and Professor Adamo. As it was introduced, my name is Anthony Zilkin, and I'm joining you online today from the vibrant city of Shanghai. It is an absolute privilege to present my research at this seminar. Today, I would like to talk about a fundamental friction in European chain law. This friction exists between bureaucratic compliance on paper and the factual reality of labor rights on the ground. Let us begin with a striking real-world example. In May 2024, a BBC investigation revealed a shocking reality in Egypt's jasmine harvest sector. Jasmine from this region is a key ingredient used by major transnational corporations to manufacture luxury perfumes in Europe. The investigation found widespread systemic child labor. But here is a legal paradox. All the European corporations involved had strict, official, zero-tolerance policies regarding child labor. They relied heavily on reputable external audit firms to verify compliance. Yet, severe violations remained completely concealed. Why did this happen? It happened because agricultural supply chains are highly fragmented. Production is not concentrated in one large factory. Instead, it is dispersed across thousands of small, informal, independent farms. In such environments, traceability is nearly impossible. Traditional corporate due diligence fails because it encounters a structural blind spot. This brings us to the core question of my research. Can the Corporate Sustainability Due Diligence Directive, the S.E.E.D directive as amended by the recent omnibus package, fix this structural risk? My analysis shows that unfortunately, in its current prospective design, the S.E.E.D directive is principally less capable of identifying abuses in highly fragmented sectors. Why? Because the directive relies on a risk-based architecture. It relies on corporate data collection. In theory, this sounds excellent. In practice, however, in fragmented and informal markets, this architecture creates what we call paper compliance. When a law demands that a company verifies thousands of small informal suppliers, the company does not send inspectors to every single field. Instead, it sends standard assessment procedures, it sends supplier questionnaires. The local suppliers who depend on these contracts fill out these forms and check the boxes. The result? A false sense of security. As Dr. Morris and Mr. Allega mentioned today, bureaucratic box checking replaces factual, verifiable knowledge. The paperwork is flawless, but the exploitation remains hidden. To overcome this limitation, my paper introduces a comparative discussion. We can look across the Atlantic to the United States and examine the Uyghur Forced Labor Prevention Act, or UFLPA. Let me be absolutely clear. I do not argue that the UFLPA is a perfect normative model. I do not suggest we just copy it directly into our EU law. Instead, I use it exclusively to illustrate a different evidentiary logic, the shifting of the burden of proof through a reputable presumption. The UFLPA shows us that when a risk is systematic and structurally hidden, credible compliance cannot rely on passive corporate policy statements. It requires data on traceable origin and independent verification. Based on this logic, I also propose a new legal mechanism for the European due diligence framework. I call it a geosectoral trigger. How would this trigger operate in practice? The law should establish that if production takes place in a well-documented, high-risk geographical zone and within a structurally vulnerable or informal sector, such as smallholder agriculture, a legal presumption of elevated risk is automatically activated. Once this geostructural trigger is activated, the law imposes a heightened evidentiary burden on the importing or controlling European company. I must emphasize, this mechanism does not establish automatic civil liability. It is a procedural tool. It forces the company to present verifiable, factual evidence regarding the exact origin of the goods, actual supply chain control, and local labor conditions. If you want to source from a high-risk, informal zone, you can no longer rely on a supplies questionnaire. You must provide independent verification. Now you might ask, how does this proposal fit into the broader landscape of EU law? Won't it duplicate existing instruments like the new Forced Labor Regulation, also known as FLR? The answer is no. This mechanism aims to supplement the FLR and not to duplicate it. The FLR acts as a market enforcement tool. It operates through product-based bans at the border. My proposed geosectoral trigger operates much earlier. It operates at the prior due diligence stage through procedural law. It changes corporate behavior before the goods even reach the borders of the European single market. Furthermore, the infrastructure for this trigger will exist very soon. As we know, the European Commission is launching the official FLR risk database. This database can provide the perfect factual infrastructure to identify these high-risk geosectoral zones. Integrating the two systems would create a powerful, unified approach. It ensures institutional coherence between the FLR and the Corporate Sustainability Due Diligence Directive, without mixing the distinct legal mechanisms. To conclude, Egypt's Jasmine case is a powerful warning. It proves that as long as EU law allows audit-based, paper-heavy compliance, hidden exploitation will continue to exist in fragmented supply chains. If the European Union truly wants to lead global corporate accountability, its legal frameworks must evolve. We must move beyond paperwork. We must develop reliable, evidentiary structures capable of disclosing hidden exploitation. Thank you very much for your time, for your attention. Grazie mille. Спасибо большое.
Thank you for your presentation, for your Italian as well, and for your stimulating ideas to see the problems from a different perspectives, and not to think always in following the schemes that we already have and the directives that we already have. And I believe that comparative law helps in doing this exercise. Now we look at a country that was European, but it's no more like this, with Michele Corgatelli, lecturer in corporate and financial law at the University of Glasgow. His presentation is about UK Modern Slavery Act and I believe also the influence of EU on UK. So thank you.
Thank you very much. Corgatelli. Yep. Grazie. Cambio con questo. Well, good afternoon. Thank you very much, Sarah. Very happy to be here. Thank you for selecting my paper. Thank you to the organizing committee and the Jean Monnet chair. So I'm working on this topic. with my colleague from the University of Glasgow, Dr. Ladna. And the paper is on this subject and will be published in a special issue of the European Company Case Law Journal under a different title. However, today I'm not presenting the paper. I'm giving a presentation on the same topic with a slightly different focus because I want to focus more on the UK experience and the lessons that can be drawn from the European Union framework. So realistically, in 15 minutes, my plan is to define modern slavery as a phenomenon, then to outline the characteristics of the approach to corporate accountability reflected in the UK Modern Slavery Act 2015, and then move on to a discussion of where the Act stands 10 years after its enactment in 2015. And whether we can draw some comparative insights from the EU sustainability due diligence framework. So let's begin with the definition of what modern slavery is. If we are here, it's because we all know that the great global value chains for the production of the goods that we then purchase extend through contractual relationships that may have obscure roots, and they may be populated by hidden workers. And the risk is that we know very little about what's going on the ground. Modern slavery it's an umbrella term that covers various human rights abuses that are criminalized individually, from forced labor, forced marriage, servitude, the exploitation of children. But these situations share the common feature of the systematic removal of people's freedom for expropriative purposes. So let me give you some data on modern slavery. Walk Free is it's a national organization. You can see the logo here in this slide. They curate a research project called the Modern Slavery Index, with the aim on trying to map the phenomenon in the world, country by country, as far as possible. And the latest version of the global Modern Slavery Index was published in 2023 and tells us that on any given day of 2021, 50 million people in the world were living in conditions of modern slavery, of which around 28 million were living in under forced labor conditions and 22 in forced marriages. Now, interestingly, the global, the Modern Slavery Index published by Walk Free also keeps track of the government responses to modern slavery. So it's in the index, they evaluate different actions taken by governments through 141 indicators, measuring the national efforts to combat modern slavery in 176 countries. And you can see here that the United Kingdom is first on the list, showing the strongest national response against modern slavery. And the UK Modern Slavery Act, adopted in 2015, it's an integral part of this response. So that's what I'm focusing on today. So let's open the Act and let's skim through the main provisions. Now, this is an Act that rationalizes public enforcement and the response of the UK government to modern slavery. So it defines criminal law offenses, slavery, servitude, force, or compulsory labor, human trafficking. Here contains in the first sections. Then you can see that the Act is divided into many different parts, mainly organizing the response of the UK state against this type of crime. For instance, this is a part on prevention orders, enforcement by sea. The Act establishes an independent anti-slavery commissioner. We have a part on the protection of victims. So this is mainly a criminal law act. But then, if we skim through the Act, we reach section 54, which is the section I'm interested in, because it deals with corporate accountability. And it's titled Transparency in Supply Chain. Transparency in Supply Chain. And I'll elaborate a bit on the approach of section 54, which is the main topic of my presentation today. So, to understand section 54, one must understand the debate that preceded its introduction in 2015, and in particular, which models were evaluated in deciding the content of section 54, because different national models were assessed. And on the one hand, one model that was considered was the Bribery Act 2010, adopted in the United Kingdom. This is an act that responds to a phenomenon, bribery, which has a strong extraterritorial reach as modern slavery. So what happened is that the OECD was putting pressure on the United Kingdom for not having implemented the Anti-Bribery Convention, and the United Kingdom, through the Bribery Act 2010, rationalized enforcement and rationalize the criminal offenses related to bribery, including the offense of bribing foreign public officials. So there is a strong extraterritorial reach to the act. And interestingly, the act contains a provision, which is section 7, which establishes an offense for companies that fail to prevent bribery committed by their associated persons. So essentially, companies are liable for a failure to prevent bribery within their organization, and they can be sanctioned with unlimited fines unless, so this is the failure to prevent bribery offense, unless the company proves that it implemented adequate procedures to prevent bribery. So basically, the company can be held liable for a failure to prevent bribery unless it proves that it had conducted due diligence on its activity. So this was a first model that was evaluated before in the development of the Modern Slavery Act in 2015. And a second model was also considered, and that's the model of the California Transparency in Supply Chain Act, adopted in 2010. So two different models: the UK Bribery Act, adopted in 2010, and the Californian Transparency in Supply Chain Act, adopted in 2010 as well. So the Californian regulation requires companies doing business in California above a certain thresholds, $100 million in total gross revenues. That requires companies to publish a statement setting out what they're doing to eradicate modern slavery from their supply chains. So the obligation is only to publish a statement on the efforts taken to eradicate slavery and human trafficking from the supply chains. And the enforcement is left to an injunctive relief of the California Attorney General to force a company to publish the statement. So again, two very different models. The UK Bribery Act with a criminal offense with unlimited fines for companies for a failure to prevent bribery. And a second model these transparency requirements adopted in California in 2010? Well, you can see, well, I told you that the title of the Californian Act is Transparency Supply Chain, and that's exactly the title of Section 54 of the UK Modern Slavery Act, so you can really figure it out what model was eventually adopted in the UK Modern Slavery Act. Under Section 54 of the UK Modern Slavery Act, companies doing business in the UK are required to publish an annual statement on the efforts taken to eradicate slavery and human trafficking from the supply chain. They can also disclose that they have not taken any steps in relation to modern slavery. So this is a very light touch approach to corporate transparency, very different from the Bribery Act. And enforcement, as in California, is left to an injunctive relief to force a company to publish the statement. And this applies to a large set of companies with more doing business in the UK with more than 36 million pounds of turnover. Now, fast forward. Oh, by the way, this approach to corporate transparency was replicated in the Commonwealth in Australia in 2018, in Canada in 2023, and in February 2026, a bill was proposed in the New Zealand Parliament. So within the Commonwealth, we have this this model of the UK Modern Slavery Act to corporate transparency. As I said, very light approach, light touch approach to due diligence. We can fast forward to the 10th anniversary of the Slavery Act, because today the Modern Slavery Act operates within a very different regulatory environment than when it was adopted. Because on the one hand, sustainability reporting has developed in the meantime. Just to mention the non-financial reporting directive adopted in 2014. This regime is stronger, but it's also narrower in terms of the companies in scope, because it applies only to large listed companies, banks, and insurance companies. And mandates a disclosure on environmental and social matters. The directive has been implemented in the UK, in 2016. And then the European Union adopted the Corporate Sustainability Reporting Directive in 2022 with a stronger regime for sustainability reporting, right? So it's interesting because in the UK, we have this very light disclosure in the Modern Slavery Act that applies to a large set of companies with low thresholds. And then we have the regime implemented by the Non-Financial Reporting Directive that applies only to very large companies, listed companies, banks, with a comply or explain mechanism, so company can disclose or explain what they're not disclosing, information related also to human rights. And then in the meantime, the European Union adopted the new version of the sustainability requirements. And so in the UK, we are still, the companies are still reporting with the previous version of sustainability reporting than the one in place now in the European Union. But then, of course, mandatory due diligence laws started to spread, just to mention the example of France, Germany, and then, of course, the Corporate Sustainability Due Diligence Directive. So today, the Modern Slavery Act operates in a very different context, different global regulatory context. So I don't have time to discuss the literature on the Modern Slavery Act in depth, but I will mention a few issues discussed in the literature on the UK Modern Slavery Act. And well, I mentioned that the enforcement mechanism for Section 54 is an injunctive relief to mandate the publication of the document in case of non-compliance. The problem is that mechanism has never been used in the history of the Modern Slavery Act, even after 10 years from the approval of Section 54, 1/3, well, 30% of the companies are not reporting. The fact is, it's costly to enforce an obligation to disclose a document through an injunctive relief instead of directly imposing fine for non-compliance. The enforcement is very weak for Section 54. And even after 10 years, the levels of compliance certainly are not optimal. And in any case, as I said, the Section 54 just requires the disclosure of a document, an annual disclosure, but the statement can say that that the company has not taken any step in tackling these human rights abuses along the value chain. There have been two different reviews of the Modern Slavery Act, one for the 5th year anniversary and one for the 10th year anniversary. These have led to very little change, almost no change at all in the wordings of Section 54. Of course, the review in 2019 recommended some changes to the enforcement mechanism, to the content of the reporting requirements. But the only thing that changed after the 2019 review is that now we have a voluntary register for modern slavery statements. It's voluntary, so companies are not obliged to upload their statement to the register. And then for the 10th anniversary, again, just to summarize in brief what I've seen in the policy documents for the 10th anniversary, I think that the main idea is, and you see it in the title of the report, becoming world leading again. The idea is that when adopted, Section 54 was groundbreaking. Today, it has fallen behind other regimes and national experiences. And again, the review recommended enhanced enforcement, enhanced reporting requirements, but nothing changed besides that today we have a new version of the guidelines adopted by the Secretary of State for facilitating compliance with the section. But this is just, of course, soft law, and nothing has changed in Section 54. A bill has been proposed at the House of Lords to introduce mandatory diligence. But the same bill was also proposed by the same sponsor in 2023. It's stalled. So, and even after the 2019 report, a bill to amend the Modern Slavery Act was proposed and was never adopted. So I will not get too excited by the mandatory due diligence bill proposed at the House of Lords. I was reading yesterday a report from Work3, the organization that I mentioned at the beginning with the data on modern slavery, because I was looking for some pictures to include in the slides. I was reading here this report, and you see here, this is a set of recommendations for the UK to implement financial penalties for non-compliance with the Modern Slavery Act. So besides for the discussion in the UK, even international organizations are pushing for a stronger regime in the Slavery Act. All right, so I'm wrapping up. And including a proposal here, you can read it in the second line. This is a proposal to strengthen the UK framework to impose mandatory due diligence legislation. This is something that, of course, has been discussed for the 10th anniversary. So I've included a table here with different approaches that could be taken in the future by the UK framework to strengthen the regime. You can see on the left hand column transparency approaches, and then on the right, mandatory due diligence. The Modern Slavery Act and the Due Diligence Directive sits at the opposite side of the spectrum, because Section 54 is very light, and the CS.EED is has a narrow scope of application, but contains, of course, stronger and overarching mandatory due diligence obligations. So well, of course, one potential trajectory for reform could be to strengthen Section 54 in light of the examples of the Australian and Canadian Modern Slavery Act. For instance, Australia provides for a mandatory register to which companies are obliged to upload the statements. Canada provides for penalties for non-compliance, the thing that I mentioned earlier, for enforcement. Or the UK could also update non-financial disclosures for large companies, because, as I said, the UK framework is falling behind the new Corporate Sustainability Reporting Directive. So this is a first trajectory. Second trajectory could be to implement mandatory due diligence on the basis of the UK Bribery Act model, which I discussed. But it's so, in theory, it would be also possible to introduce mandatory due diligence only for modern slavery, so these specific adverse impacts, or eventually an overarching due diligence framework. And I'm concluding on this note by saying that this is one of the most important points that I want to make today. The CS.EED has an extraterritorial effect because it applies to companies incorporated outside the European Union that have a large turnover in the European Union. And at the same time, the Modern Slavery Act applies to companies incorporated outside of the United Kingdom, because if they're doing business in the United Kingdom. So it's possible that a company fall within the scope of both regimes at the same time. That's the topic we are exploring in the paper that I mentioned at the beginning of this presentation, which is a different topic, different focus. But it's possible that the company falls within scope of multiple due diligence frameworks. Now, the problem is, today, there are no conflicts between the light transparency in the Modern Slavery Act and the Due Diligence Directive, because the Due Diligence Directive mandates what to do, and Section 54 just mandates to be transparent on what you're doing, right? The problem is that, given that these frameworks have an extraterritorial reach, if the UK were to introduce a mandatory due diligence framework, that would apply to companies already in scope of the CS.EED. So it's very important that when developing mandatory due diligence laws, the frameworks do not conflict and do not impose different requirements to manage the same adverse impacts within the value chains. So the CS.EED cannot impose a certain behavior in relation to a contract than another national mandatory due diligence framework, right? So this is something to be considered in light of a potential reform of the UK framework. Thank you very much.
Thank you, Michele. Yes, I believe that this last problem can be really challenging, but I don't know if we are lucky or not, but I believe that we are a bit far from that moment. And in the UK, in the end, the functioning of this article with a comply or explain mechanism, because companies can just say, no, I'm not doing anything. It's closer to the European approach in 2014. So yeah, we will see, but now I don't believe that we have problems of compulsory acts that go against each other, unfortunately. But thank you again. And last but not least, Wang. Sorry. Okay. Thank you. She is a PhD candidate at the Institute for Labor Law, Q Leuven. and she took her master degree at one university in China. So she are going to present a case from the point of view of China, EU-China supply chain. So I'm sure you will be able to respect the 12 minutes, so thank you.
Good afternoon, everyone, and thank you very much for the opportunity to present my work here. And my presentation is about the implementation side of due diligence through a case study of EU and China battery supply chains. I will explore the process through which due diligence requirements travel into China's context and how they may shape corporate practices on labor rights related issues. And first, I would like to talk about the regulatory background of my research. I put this research in the mandatory due diligence framework, and more specifically, the CS-DDD. And the CS-DDD clearly has extraterritorial effects. There are two routes through which the CS-DDD may be relevant. First is direct coverage. Some Chinese companies may themselves fall within the scope of the directive if they meet the EU turnover thresholds. But at this stage, there is not enough and publicly available information to identify which Chinese companies are directly covered, especially after the Omnibus 1. And the second route is through supply chain relationships. An in-scope company may have Chinese subsidiaries or Chinese business partners in its chain of activities. And here, the in-scope company may be either an EU-founded company or a third country company directly covered by the directive. Here I use Chinese companies as example, but the same logic applies to companies in other third countries. But in practice, the problem is in practice, companies do not operate only under the CS-DDD. They operate in a multi-layered regulatory environment shaped by many different legal and policy frameworks at the same time. From China's side, what has been changed recently is that the first regulation at national level regarding supply chains was promulgated this year, and it's already in force. I'm not going to introduce the whole regulation because the main part of the regulation is about supply chain security. But there are two provisions that are particularly relevant for due diligence. First is Article 13. It concerns investigations and other information gathering activities related to supply chains. These matters because due diligence depends heavily on supply chain information. If information collection is considered to violate Chinese regulations, it may become legally sensitive for multinational corporations. And another one is Article 15. It concerns foreign supply chain conduct, including interruption of normal transactions or discriminatory measures against Chinese entities. And these matters because due diligence is not only about collecting the information, it also involves remediation, corrective actions, suspension. And these actions now have possibilities to be framed as supply chain security issues under Chinese law. And of course, at this moment, we do not know yet how much these provisions will be applied in practice because it's relatively new and the enforcement scope remains to be observed. But at the level of articles of legal framework, they already shows that supply chain due diligence may enter a regulatory scope under Chinese law. Okay, and from the EU side, the relevant recent development is Omnibus 1 package. I'll not discuss the whole package because other presenters or speakers have discussed in detail already, and I only highlight 2 amendments to Article 8 of the C.S.E.E.D because they are directly relevant to how companies identify and assess risks in supply chains. First, for business partners, with fewer than 5,000 employees, information may be requested only where it cannot reasonably be obtained by other means. And second, companies may prioritize assessments involving direct business partners, the first layer suppliers, where risks are equally likely or severe. So these amendments, of course, they do not mean that due diligence stops at the first tier suppliers, but the logical result may be that companies may make due diligence more cautious and restricted and more direct business partner oriented in practice. So my argument here is that EU companies may have fewer incentives to trace risks further upstream in supply chains, in EU-China supply chains, and probably adopt a more cautious strategies. This is because both the regulatory pressure from the China side and also the simplification of Omnibus 1. So what do these changes lead to? My argument is that they make localization more important. If EU companies become more cautious in directly collecting information or intervening further upstream, then due diligence cannot rely only on pressure from European importers. Instead, it may need to operate through local actors, more local actors who are already positioned within the supply chains and also within Chinese context. For example, the Chinese lead firms, and they can organize upstream suppliers, translate external due diligence expectations into internal management rules, and make due diligence operate through more ordinary and potentially less sensitive commercial practices. So here is some data to justify my choice in the case study part. First is electrical equipment is the largest EU import category from China, and vehicles and parts also ranks 4th. So power batteries, the EV power batteries are related to both the 2 flows. They are classified within electrical equipment, but they are also key components of electrical vehicles. I then focus on CATL and FD battery, also known as BYD. They are 2 leading Chinese battery firms and together accounting for more than half of the global EV battery market. So this is a sector with comparatively high market concentration. And what's more, generally speaking, an export-oriented sector tends to be more sensitive to international standards and EU regulatory pressure. This makes the battery industry a useful testing case here. So this figure shows the dual role of Chinese battery lead firms in labor-related due diligence. On the one hand, they directly receive due diligence pressure from EU importers, so they may need to manage labor rights issues in their own operations. On the other hand, they also transmit due diligence expectations further upstream, and the cascading part is my main focus today. This slide shows the main normative sources referenced in the 2 companies' supply chain policies. The first layer is international standards, and the second layer is Chinese industry guidance. The CMC the words in red is the China Chamber of Commerce of metals, minerals, and chemicals importers and exporters. So in the Chinese context, such industry chambers often have a government-linked character, and more importantly, the CCCMC guidelines were developed in cooperation with the OECD. So this is a Chinese industry version of translation of international due diligence norms. And the third layer is EU regulation. Although it's due diligence obligations,
Sorry, just one thing, but those guidance are soft law or binding?
In Chinese context?
Yeah.
I don't think it's soft law because
it's mandatory, okay.
And not mandatory, but not all the companies are covered by these. I think it's only lead firms and yes, lead suppliers.
But those that are involved must follow those guidance.
Yes, if you are a member of it, then it's a must.
Okay.
Yes. And so okay, well, okay, it is it's okay. And yes, it's the EU regulation. Yes, although it's due diligence obligation parts of the EU battery regulation have been postponed to 2027. It's the same approach as Stop the Clock as Omnibus 1. So, but in the case study, I found that both companies expressly refer to this legislation in their public documents. This shows that Chinese lead firms are actively responsive to regulatory changes even before the EU battery due diligence obligations are formally applied. Okay, and on this slide, I use the ILO fundamental labor rights as an evaluation tool to examine labor rights coverage in the internal policies. The general supplier, we can see that there are two categories. In the general supplier policies, a broad coverage of fundamental labor rights is found. But in mineral supply chain risk identification, the coverage becomes narrower. Forced labor, child labor, and occupational health and safety are clearly covered, while freedom of association and discrimination are much less visible. So this suggests that labor rights are indeed incorporated, but risks are identified and prioritized according to the likelihood and severity in a specific sector. So this slide looks at what happens after risks are identified. For CATL, it appears to rely mainly on an entry control logic. Suppliers need to meet minimum ESG requirements to enter the procurement system. And I think from my side, this is, from my point of view, this is a closer to a certification or labeling model. But by contrast, FDE batteries policy appears closer to a CS-EED style due diligence logic. It does not only set entry requirements, but it incorporates responsible sourcing requirements into supplier contracts. And then they identify different categories of upstream risks and provides different response measures then depending on the nature of the severity of the risk. Okay, I still have 3 minutes. So from the slide, it shows that the immediate suspension only applied to severe abuses regarding human rights, including forced labor, child labor, workplace violence. And for broader labor-related risks like work time and the payments, the company will issue an action plan with the suppliers, and that's what I can read from the supplier rules. So compare with the CS-EED's approach that's specified in Article 11. It first requires the company, the importers, to neutralize or minimize the impacts, the human rights impact, and then suspension will be used as a last resort. But in FD batteries internal rules, it shows that the suspension is the first choice when it is related to forced labor and child labor. So it probably means that the company just wants to cut off the relationship when they identify this risk. What the case study suggests, I think, is 3 points. The external standards are absorbed into internal supply chain management rules, of course, and helping due diligence expectations travel further upstream. But this localization is, the process is selective. Like similar external norms may be interpreted differently, even within the same sector, and companies absorb due diligence requirements selectively that best fits their own risk management strategies. And towards minimum labor regulation, the next step, I think, is to move beyond the citation, simply the citation of standards, and translate these standards into concrete supply chain governance practices. Yes, I think my time is up. Okay, so it's fine.
Thank you so much. So thank you to everyone. I don't want to take other time because we can have just few minutes for Q&As. I want just to trace a common thread using a sentence that one of you pronounced that I really appreciated, that can be a bit of the sense of this panel. One of you said that the CS-EED creates pressure for due diligence. It doesn't mean that the CS-EED is the right model, and of course we have to avoid paperwork and other externalities and things that doesn't function properly, for sure, but the fact that a European Union with those directives is somehow pushing all the world to think about solution for sustainability, human rights, and environmental sustainability, it's really positive. So we don't have the answers maybe, but the fact that these directives are doing pressure for sustainability, it's something for sure positive. There are questions for our panelists. Okay. I know it's Friday afternoon, so thank you again to all of you. And I leave the floor to Professor Mocella. And okay, wow, thank you. So we have 5 minutes break, and then, yeah, okay.
Is it clear? Thank you. I already sent it to Christina. Okay. Okay. Through WhatsApp?
Yeah, or I'll get you mine.
Okay. Easier. Thank you. I'm not sure. You just enter a number? Maybe this is your number? No?
No, I didn't enter.
Wait, maybe you just enter a number here. Thank you. No? Then I'll enter it. Here. What's the 3-1? Netherlands 3-1. 406. 69406.
Check it for some reason. It's very difficult to remember my phone number.
Yeah, because in Netherlands it comes the number and 2 together, right? It's 30. Just I know. Just Okay. That's clear because I'm afraid I don't have enough time, so I just go super fast. If you want, I have oh, actually, you can show me putting all the Okay, is that me? You got my number? Yeah. LinkedIn? Okay. I actually have okay. The Chinese the guideline. Yes, guideline. Yeah. You mean the 16th? Yeah.
Yeah? Adriano, yes, that's one there. Yeah, I got it. Got it. And then this could be. Okay. Different. Yeah. Well, maybe this one. It's great. Okay, we're under good supervision. Excellent. Dipende da come. Questo è la cambiare il
Questo è il telefono. Sì. Accendo il laterale, però per ora faccio la dimensione in piedi. Ho detto dove stare al centro, io mi arrendo. Siete padroni ormai, ho capito. No. Okay, we begin the last panel. First of all, would like to thank everyone to participate to the seminar, our guest Luca and Bas, and everyone to participate to our call, because without you, these seminars couldn't be so interesting. I hope it's been. A selected jury examined all the paper, and we are very happy to award the best papers. And 2 of them are online, so we congratulations. Then we send the certificate of award online by mail. So congratulations to Sabir Hassan and Anthony Zilking. I give you an applause for both. And in presence, Maria Giovannone, but is not here in this moment, but I gave this morning the certificate. Now I would like Paio Morris, if you can give here. Thank you. And so I give you the best paper award for you, for your paper. S.E.E.D, access to effective remedies for victims of labor rights violation in supply chain. Thank you very much. This is for you, a photo. Okay. And when we organized this call, we imagine an award, but also a scholarship for students for best paper for developing country. So the same jury selected the paper of Ching-Wang, Korea. So I give you the certificate, on my photo, and very, very congratulations. A lot of congratulations, and we send you the money too, huh? Ok, mi siedo adesso. So at the end, we are very, very emotional to have here our guest of honor, because I think after the slowdown of the Omnibus One Package directive from the two directive of due diligence, I think an important role will be done from the next year by the European Court of Human Rights, because a lot of rights of workers are also human rights. So very important for us to have today here Raffaele Sabato, Italian judge to European Court of Human Rights. So many thanks to be here. The floor is yours. Prego.
A few words in Italian to start with. Grazie al professor Mocella per aver organizzato questo corso che mi ha dato l'occasione questo pomeriggio di condividere parecchi punti di interesse comune. Mi complimento con i relatori. E poi grazie al professor Santoni per la sua autorevolissima presenza. Il professor Santoni è stato per noi, io sono un magistrato italiano, un punto di riferimento imprescindibile lungo tanti anni, nel momento in cui il diritto del lavoro e il diritto sindacale hanno affrontato tanti cambiamenti. È stato un punto di riferimento e una guida imprescindibile e continua ad esserlo con la sua vicinanza e il suo affetto. I've been working now for 5 years at the European Court of Human Rights. Not everybody is probably acquainted fully with, so to say, the internal cuisine of this court, but I will say a few words in that regard. The European Court of Human Rights is based in Strasbourg, is based on a convention which was signed in 1950 here in Rome, has a larger constituency than the European Union because it encompasses 46 states. They used to be 47, but unfortunately, you know what happened with the Russian Federation. And this convention is a convention containing basic principles in the area of human rights, so that the court works as a sort of insurance policy that European countries have freely subscribed to, accepting that an international supervisory mechanism exists based on principles, based on the role of judges, based on precedents, based on a number of doctrines, including the doctrine so-called of the living precedent, which is a sort of evolutionary interpretation of the convention in the light of present-day conditions of society, and another concept of European consensus, which means that in interpreting convention rules, we keep into account what not the majority, but the widest understanding of human rights is in Europe, not necessarily what was in 1950 when the convention was signed. We are developing an information tool for users, not only legal experts or legal practitioners, but also the general public and especially journalists. We are, as you might imagine, confronting the most important crisis after the 2022 events. The very thing that the convention was aimed at avoiding, war on the European territory, took place. It took place at the heart of Europe, and the court is still delivering judgments against the Russian Federation for a 6-month period after the aggression. So you can imagine that we have cases that deal with the very core of human rights at this time in Europe. I have prepared a little outline of what I will briefly say. I will cover some environmental cases and then climate change litigation. Before doing that, I wish to sort of say a few words on the widest concept of business and human rights, which is the linking connection between the topics that I've seen you've dealt with in this seminar and our work on an everyday basis in Strasbourg. These are the topics that you usually cover when you talk about business and human rights. The court has cooperated. I have personally cooperated in this project of a European Law Institute, which is a sort of paste and copy of the American Law Institute proposing actions to the European Union. And so we have had our voice in working on the directives that you have been commenting during the seminar. One, so to say, historical reflection that I was making with Professor Mocella as we were having our pause, we recognize in Strasbourg that the very idea of having the right of individual application in Strasbourg, and on the other hand, having some limited company and business litigation before a court which is a court of human rights, is the direct consequence of your own field of interest, the intersection between labor law, trade union law, corporate law, and on the other hand, due diligence in the area of social responsibility and the like. Why? Because in the 30s, as you know, we had the first international conventions that started having the word companies, corporation, etc. in international law. They were more, so to say, aimed at protecting competition rather than at protecting individuals and or their rights at work, their right to pay, their right to hygiene on the place of work, etc. But in the end, these gave rise to the role both of individuals and company in a field of law in which there was only the role of the state. This idea that developed beginning in the 30s, you have examined in depth during your seminar. If I have to only add one remark, please do consider when you talk about European Union that in Strasbourg at the Council of Europe, that is the umbrella organization under which the court operates, we try to replicate whatever is done at the European Union level. And in the area of what was once corporate social responsibility and is now due diligence with special reference to human rights, we did not copy-paste. It was the European Union that copy-pasted our copy-pasting of the UN Human Rights Council adoption of the Business and Human Rights Guiding Principles of 2008. So in Strasbourg, we take those principles, we expand them, although not always in a binding way, but here we have recommendations, so they are internationally binding for the whole group of 46 states belonging to the Council of Europe. So that's the only, so to say, consideration that I feel to make in your program. Regarding this, I have proposed to Professor Mocella that maybe after this seminar you could have a visit to Strasbourg. The human rights system is not only the Convention on Human Rights, it's also a whole number of other instruments that my court is not called to apply, but that we can consider in order to draw inspiration. Among those, of course, the European Social Charter and its quasi-litigation mechanism before the European Committee of Social Rights. So that's another parallel system that we should consider when we talk about these topics. And they are more and more dealing with business and human rights topics. But now I have to finish, and we have to go to the environment. So basically, what I would like to call to your attention is that the idea that individuals bring environmental cases before an international court started before my court in the 1990s. And ironically, the first case was an Italian case. Actually, no, it was there was a Spanish case before Guerra, which was called the Lopez Ostra versus Spain of 1993. But basically, Spain and Italy are among the bad countries in the field of environmental protection. One legal comment in this regard is that the convention does not at all mention a right to the environment, or even less a right to a stable climate. Therefore, because our case law is a case law based on precedents, most of the litigation usually would start under Article 2 or Article 3, that is the right to life or the prohibition of ill treatment. And in most cases, the court would requalify. This happened until a couple of years ago in a constant way, this kind of complaints under another article, Article 8, the right to protection of private life. So this is what happened in Guerra. This is what happened in Lopez Ostra. I said 1993, it was 1994. And this is what happened in a number of cases concerning not what we would consider industrial emissions, such as especially Guerra or Lopez Ostra, but also in developing contexts, such as in Cordella versus Italy, the idea that a balancing should take place between industrial work factories as such and the need of workers to earn living wages, as you have commented from another point of view. Now here, what is for sure is that in the end, in 2019, my court found a violation. That was the year I was, for the first time, attracted to the court. But the Italian Constitutional Court changed its case law, having two contrasting cases, in which one time said that it was more important to protect labor and not to protect the environment. And in the next judgment, which I noted in this, they went differently, as the awareness for the importance of environment on the health of workers themselves had increased in society. Then, of course, we have a number of cases. This is one of them, Locascia and others versus Italy, that have nothing to do with industries. Locascia and other cases such as Desarno versus Italy concern the living conditions of the population at large. So this was a further step. These are the cases that address the so-called waste management crisis in one region of Italy, the region surrounding Naples. And we find violations again of Article 8 because the living conditions in those towns were practically impossible. There was no recognition or award of damages, but the violation stood nonetheless. The big change took place with climate change. So a famous Netherlands case, the Urgenda case, you might know of, took place domestically, and the Dutch Supreme Court recognized that associations could litigate on behalf of future generations. The Netherlands have their own very peculiar system of sources of law, including the European conventions among sources of domestic law. So they referred directly to Articles 3 and 8 of the convention. It was very creative. They ordered to the state to decrease the level of emissions, and they used the Rio and the Paris principles, although, as you know, they were not binding, and although, as you know, they were apt to be changed over time, they had general goals, but they started using them. The role of association was based on a wide interpretation of the Aarhus Convention, which called the states to recognize a role for association to litigate in, be careful, environmental cases. And this was not an environmental case as such. It was a case that dealt with emissions of greenhouse gases changing the living conditions, not of a given situation with a relationship, a physical and a personal relationship with a place, but in general with the world. I cannot mention all the points that could possibly be relevant, but there was litigation, as you know, in this area before the some national constitutional courts, having in Germany, we had this Neubauer case because in Germany they had a domestic legislation. There is a pending case in Italy. There are some other pending cases. There was a Carvalho case brought before the European Court of Justice. What happened in September 2023 is that I found myself involved. And this is why Professor Moscella probably called me here to address you very, very briefly. We decided to relinquish to the Grand Chamber, meaning that a group of 7 judges, we decided that we could not possibly deal with such an innovative area of the law. And so we sent some examples of the cases that we had before us. And I was involved because there were 2 Italian cases pending at the time. And we sent 3 cases that were sort of representing the universe of litigation before us to the Grand Chamber, so that 17 judges would decide. A number of procedural measures were taken to have these 3 cases decided together by the same judges. And then at the very last deliberations, one woman colleague unfortunately got ill and could not participate. So there is a little difference in one case. There is a substitute stepping in, but what is sure is that in April 2023, we found ourselves coming out with this one judgment and two decisions, accepting one application and rejecting for inadmissibility two other decisions in these famous three cases that are called Verein Klimaseniorinners versus Switzerland, Carême versus France, and Duarte Agostinho, a lady with this last name, and others versus Portugal, plus 32 other states. Among these 32 other states, we had Italy, and the 33 states were the signatories of the Paris Agreement. What happened in Verein Klimaseniorinnen, in which we found a couple of violations of the convention, Article 8, and above all, Article 6 of the convention, a right to fair trial. I have written a little article, a little doctrinal article in which I submit that we transformed this kind of litigation from substantive to procedural. Because the Swiss Federal Tribunal had not recognized the role of the association of the old ladies that were complaining for excess of heat that had prevented them from going out from their senior persons' residence in Switzerland for about 20 consecutive days. Well, they had not recognized the role of associations. They had dealt with the application of the individual ladies, but they had said that they had no specific right as individuals because they were not directly affected, because they did not have a right to have a specific measures taken by the Swiss parliament, because they were still in time and the Paris objectives would be reached based on the discretionary decision of political power. Now, to conclude, we found that this was the first thing that was wrong. We rejected, and the press did not clarify that there was this rejection. We rejected ourselves the claim of the individual ladies because they had not suffered a ill treatment that went above what we call the threshold of gravity of the convention. The association role was rather emphasized by us. So we sort of took the idea of the Urgenda case and recognized that a serious association existing for some years, having a wide membership and having as main objective the one of dealing with climate change topics, would represent not the members, but some collective interest to a stable climate. In a way, recognize the so-called intergenerational link, which was a step on which you can imagine we reflected for months, and we are still, so to say, very doubtful about, but in the end, this was recognized as a major progress. And so now I'm proud that I've been part of that. I cannot go in details, and I think I have to finish. Very, very quickly, I would mention two other areas of our case law. A first area concerns the progress that we had in January 2024, when we, again, unfortunately, against my own country, Cannavacciuolo, we found a violation of Article 2 against Italy, right to life. Cannavacciuolo is a case dealing with the so-called terra dei fuochi phenomenon. I will say a few things in English and then I would finish using Italian. The idea in this case is that for the first time, we find that the state has a duty to monitor the situation of a territory because the substantive case was one in which private owners, often in conjunction with organized crime, had allowed industries, and this relates again to you, to bury toxic waste in agricultural land, which had prevented safe cultivation and harvesting of vegetables, growing of animals, breeding of animals, and will do so for years, if not centuries. The procedure that we followed is called a so-called pilot judgment. So we gave 2 years to the state to find a solution. At the time, there was no enumeration of the sites. There was no knowledge of the so-called qualification of the site, meaning what is the pollutant here, what is the pollutant there. The government did not object to the judgment and appointed a special commissioner who is starting dealing with the problem. Of course, I heard about remediation mentioned by our speaker from Leuven. I think that the basic importance of this judgment is that it's based on remediation and provision of information to the public. Italy had had 15 years of state secrecy on this phenomenon. And so there was a parliamentary inquiry of which the population did not know the content. The really final remark that I would like to make has to do, and I have problems with, has to do with a recent development in the area of, I wish to go to the last one. Okay. Yes, here, of course, the climate case judgments have had resonance and replication in a number of other further advisory opinions from several international courts. I know that here we have one professor from Brazil. So the second one to intervene was the Inter-American Court of Human Rights, but we also had in 2023 an advisory opinion in July 2023 of the International Tribunal for the Law of the Sea, all going into the same direction that I mentioned. And then recently we had an advisory opinion of the International Court of Justice. Sorry that I forgot that. The final remark I will make in Italian. La cosa che a me pare più significativa adesso nel contenzioso sia ambientale che climatico dinanzi a una corte internazionale, tenuto conto di queste sentenze sia della mia corte sia dei pareri consultivi degli altri organi internazionali, è capire cosa uno specialista di diciamo, diritto delle corporazioni, di diritto del lavoro e diciamo, dei temi che avete trattato voi può eventualmente considerare rilevante. Io credo, dopo aver sentito qualcosa dei vostri temi e letto i vostri argomenti, che la prima cosa da rilevare dal punto di vista della corporation law, del diritto commerciale, ho sentito che si parlava di un top-down approach, per cui all'interno dei gruppi societari vi sarà questa, a seguito della due diligence, una trasmissione di voglia di far qualcosa. Io credo che dopo le nostre sentenze, avendo un po' sondato gli umori anche politici in Europa e con l'eccezione ovviamente di alcuni settori e di alcuni paesi, questo è il problema del momento, dobbiamo immaginare che vi sarà una cosiddetta cambiamento interno identitario delle società, in quanto gli azionisti dovranno pretendere dai loro manager di incorporare la sensibilità al tema ambientale, non solo, quella già c'è in qualche modo, ma la sensibilità al cambiamento climatico all'interno degli obiettivi societari. Vi sono poi altre cose che riguardano più che altro il diritto dei consumatori e le questioni relative ai sussidi, alle tasse, a come l'Europa si muoverà in questo settore. Certo, il rinvio della data di entrata in vigore della direttiva va in un senso completamente diverso, ciò che è legato anche alla crisi energetica. Dal punto di vista della Corte Europea dei diritti dell'uomo, noi abbiamo fatto un caso che si chiama Greenpeace Nordic contro Norvegia, che per la prima volta ha utilizzato e ha ritenuto non violazione da parte della Norvegia, ha utilizzato un criterio un po' formale di verifica che vi fosse una accettabile valutazione di un impatto, diciamo, ambientale, in effetti un impatto del cambiamento climatico anche in maniera transfrontaliera, senza andare troppo nel dettaglio, senza sostituirsi agli stati. Questa sentenza è stata interpretata anche come un nostro passo indietro da molti osservatori. Io non lo credo, ma ve lo dovevo per completezza riferire. Mi fermerei qui.
Continuo in italiano anch'io, switch in italiano. Credo che l'intervento di Raffaele Sabato sia stato per tutti noi interessante, a dire poco, perché ci mostra come i temi che la Corte Europea dei diritti dell'uomo affronta, e come anche le altre corti internazionali si devono affrontare, intersecano i nostri diritti, cioè i diritti che noi, diciamo, studiamo come diritto commerciale, come diritto del lavoro, in maniera piena. Non avevamo dubbi che il ruolo della Corte, come ho detto, diventerà sempre più importante, perché inevitabilmente dovrà supplire a quella carenza che, diciamo, lo stop delle direttive ha rappresentato e rappresenta per ora, e quindi io sono sicuro che diciamo, accogliamo con piacere innanzitutto l'invito, così lo blocchiamo. E quindi abbiamo detto sì, quindi abbiamo accettato l'invito, ma comunque credo che sia utilissimo questo rapporto che si crea con la Corte. E noi come, diciamo, cattedra di sostenibilità e due diligence effettivamente ci poniamo questi temi, ad affrontare questi temi, per cui il dialogo con le corti è fondamentale. Ciò detto, io passo alle considerazioni conclusive, non prima di avere detto una parola di ringraziamento al professore Santoni, che come alcuni di voi, molti di voi sanno, è stato per oltre 30 anni, direi anche 35, professore, purtroppo, diciamo, nel senso che per me anche, dico, è il mio maestro, purtroppo per questo, fortunatamente anche per altri 35, però questo rappresenta il fatto che una volta ero un giovane, questo adesso sono, diciamo che la categoria giovane non mi appartiene più. Comunque sono veramente ormai tantissimi anni che seguo con prima le lezioni, poi diciamo la tesi, poi successivamente, e questo è sempre stato al mio fianco in tutta la mia carriera accademica, anche dopo essere andato in pensione, quindi per me oggi averlo qui ospite in questo evento, per noi molto importante, non poteva che essere un motivo di grande gioia e volevo condividerlo con voi. Ci ho detto, penso che potrà soltanto nel concludere il convegno apportare le sue considerazioni, tra l'altro sono temi che recentemente sta studiando, e quindi fa molto piacere che possa condividere con noi le considerazioni a cui è giunto. Prego, professore.
Grazie. Io mi scuso di non poter parlare inglese, ma appartengo ad una generazione di giuristi che hanno dovuto studiare il tedesco. Poi l'ho anche dimenticato per strada, ma comunque Quindi mi limiterò a fare qualche considerazione di contorno in italiano, scusandomi con quelli che ci ascoltano da remoto, che non conoscono la lingua. Io sono venuto qui in questa splendida sede su invito del mio amico Marco Mocella, soprattutto per incontrare Raffaele Sabato, che oltre a essere, diciamo, un magistrato autorevolissimo, è anche un amico mio e anche un amico di famiglia, quindi sono molto contento che siamo riusciti, Mocella ed io, a far intervenire in questa sede il presidente Sabato, che già altre volte ci aveva promesso che sarebbe venuto, però poi per i suoi impegni così importanti nella Corte dei diritti dell'uomo non aveva potuto in passato essere presente. E poi mi rammarico di non aver potuto ascoltare ieri Luca Nogler, al quale sono molto legato da un rapporto di amicizia di vecchia data, perché Luca Nogler è un giurista di quelli colti, è uno dei pochi giuristi lavoristi colti che diciamo coniuga sia il profilo tecnico con il profilo culturale di altissimo livello, perché veramente devo dire che Luca Nogler ha dato dei contributi importanti alla nostra materia. Che dire, conclusioni non ne posso fare, sia perché non sono stato presente nella giornata iniziale, sia perché ho potuto ascoltare solamente gli interventi, alcuni interventi di questa mattina e gli interventi di oggi pomeriggio, tutti di elevato livello. Io noto con piacere come queste giovani generazioni di studiosi, sia del diritto commerciale che del diritto del lavoro, sono molto, diciamo, importanti, anche molto profondi, approfonditi, non solamente su questioni di dettaglio, ma anche su profili generali. Questo tema è un tema circolare, come veniva ricordato anche dal Presidente Sabato, perché involge sia il diritto commerciale, sia il diritto del lavoro, sia il diritto dei consumatori, sia il diritto dell'ambiente. Quindi, come dire, veramente bisogna essere consapevoli che ci sono queste materie che possono accomunare una riflessione interdisciplinare e che è quantomeno necessaria. Io vorrei fare una considerazione, diciamo, più generale, che è quella dell'anomia del nostro sistema legislativo lavoristico, perché noi abbiamo la nozione del diritto commerciale sui gruppi di imprese, che naturalmente viene traslata anche nel diritto del lavoro, ma non so se oggi possa bastare. C'è, è vero, quella normativa sulle reti di impresa che è stata, diciamo, emanata più recentemente rispetto alle discipline commercialistiche, che può avere un, diciamo, impatto in qualche modo rilevante per soprattutto andare ad individuare l'identità dell'impresa. E poi c'è la giurisprudenza anche della Cassazione, che sulla codatorialità ha fatto dei passi importanti, perché ci sono delle sentenze tra il 2025 e il 2026 che hanno praticamente superato quella che era l'impostazione iniziale di valutare la codatorialità come una integrazione funzionale e non solamente come con un intento elusivo, quindi allargando quella che poi è la conseguenza del collegamento tecnico-funzionale fra le imprese, che diventa rilevante soprattutto quando ci sia un utilizzo promiscuo e indifferenziato della prestazione, che rende indistinguibili poi a quale datore la stessa sia concretamente riferibile. Qui si potrebbero dire tante cose, un inserimento dei lavoratori in un'organizzazione economica complessiva del gruppo può essere valutata in senso ampio in un contesto di economia interconnessa e di filiere produttive sempre più integrate, e quindi la Cassazione, a mio avviso, segna una tappa verso una ricostruzione funzionale dei rapporti di lavoro in cui la forma cede al contenuto e la responsabilità solidale fra tutti i codatori, ai sensi dell'articolo 1294 del Codice Civile, sostituisce la frammentazione. Poi ci sono anche dei profili, come dire, sulla responsabilità solidale che possono riguardare non solamente il profilo economico, ma anche il licenziamento. Qui io mi pongo un problema un po' più complesso, perché la reintegrazione ha, diciamo, una tecnica di tutela che è particolare rispetto alle obbligazioni pecuniarie, quindi non so se questi risultati degli arresti più recenti della Cassazione possono addirittura essere utilizzati anche per la tutela del posto di lavoro. L'altra questione riguarda invece questa questione della due diligence, che è stata molto bene analizzata in questa sede. Certo, il punto di partenza sembrava molto incoraggiante, poi dopo il pacchetto Omnibus vi è stata una sorta di controriforma, per cui in questo mutato contesto si va a ridimensionare quello che erano le aspettative, per cui sia dal punto di vista della riduzione della platea delle imprese coinvolte, sia sull'attenuazione degli obblighi previsti, sia sul rinvio dell'entrata in vigore di numerosi adempimenti, diciamo che la questione della due diligence viene, come dire, per il momento ridimensionata, se non parzialmente accantonata, perché prevalgono interessi di natura economica che sono molto rilevanti in questo settore delle catene di valore. Certo, qui il problema della tutela del lavoro nelle catene di valore è un problema assai rilevante, che non si è posto solo da ora, perché l'Organizzazione Internazionale del Lavoro ha emanato norme risalenti sul divieto del lavoro forzato. Io ho appreso con interesse in uno degli interventi del pomeriggio che in Inghilterra e nei paesi del Commonwealth vi sia questa legislazione che cerca di affrontare la questione del lavoro forzato. Però certamente, come dire, la presenza di garantire ai lavoratori i diritti fondamentali imprescindibili è un problema, diciamo, di non poco momento, perché, come dire, codici di condotta, clausole sociali e accordi, come dire, internazionali non è che garantiscono poi nell'immediato e nel concreto la tutela del lavoro. A parte i limiti più generali della giustiziabilità di questi diritti fondamentali, di cui uno spaccato ci è stato anche fornito dal Presidente Sabato, c'è anche un problema di collocare questi codici di condotta, queste clausole sociali nel sistema delle fonti internazionali del diritto del lavoro, e quindi l'assenza di un carattere obbligatorio e la loro ridotta effettività rende problematica l'attuazione concreta della garanzia che in linea di principio si vuole perseguire. Anche queste forme di regolazione indiretta realizzate attraverso l'impostazione di obblighi di trasparenza e di diligenza che mutano e rafforzano i principi propri della due diligence possono segnare un passaggio da una dimensione volontaria ad una dimensione un po' più precisa, un po' più significativa, però sempre diciamo, sul piano giuridico rimangono delle problematiche, come dire, abbastanza delicate. E di questi aspetti sono stati già approfonditi abbastanza approfonditamente in questa sede. Per quel che ho potuto ascoltare io veramente devo complimentarmi con tutti quelli che si sono succeduti nella esposizione, perché hanno anche fatto emergere come anche in lontani paesi come la Cambogia, il Bangladesh, dove la Turchia stessa, dove diciamo, la globalizzazione ha spinto più che in altri paesi, in altri ambiti geografici, lo sfruttamento del lavoro, si è cercato almeno in linea di principio, se non con qualche risultato concreto, di affrontare un problema di non poco momento. Io vorrei tornare invece all'ordinamento nazionale, perché nel diritto del lavoro italiano ci sono state delle normative significative, a parte l'ultimo provvedimento legislativo sul caporalato informatico, che non sappiamo dove possa, diciamo, portare, perché indubbiamente dove c'è l'algoritmo c'è un maggiore sfruttamento e quindi una esigenza di maggior tutela. Però noi abbiamo avuto la riforma del codice penale, l'articolo 603 bis, nella versione modificata nel 2016, perché quella precedente, che era stata introdotta dalla legge 148 del 2011, aveva avuto una scarsissima applicazione, che rafforza le sanzioni nel momento in cui il somministratore e il soggetto utilizzatore diciamo, vengono diciamo, tutelati nello stesso modo, e soprattutto dove gli indici di sfruttamento comprendono sia la retribuzione inadeguata che le violazioni di orario e riposi, la carenza di sicurezza e condizioni di lavoro degradanti. Questo mi sembra un passo, diciamo, avanti. Certo è un problema che riguarda prevalentemente i settori dell'agricoltura e il settore edilizio, ma può anche avere una portata più ampia, dipenderà dall'applicazione che verrà fatta in concreto. E poi c'è anche un altro problema che molto spesso rimane in ombra. Io ho partecipato al convegno di Capua, organizzato dal PRIN, che era stato diciamo, svolto soprattutto sulla nozione di impresa integrata, e lì, come ricorderanno i presenti, lo stesso professore Mocella, che è sempre stato molto attento a queste tematiche, perché lui ha scritto anche una bella monografia sulle reti di impresa, che nella fase iniziale in cui si cominciava a studiare questo problema, e praticamente si è parlato sia in quella sede di impresa integrata, della nozione di impresa integrata, soprattutto con gli interventi di Alvino, di Bellomo e di Valeria Filì. Ma è rimasto in ombra un problema che invece ho visto che anche recentemente è stato valorizzato con la maggiore attenzione verso le misure di disposte dal Tribunale di Milano come amministrazione giudiziaria nei confronti di alcune aziende che hanno, diciamo, soprattutto nel brand del lusso e della moda, come dire, dove maggiormente si sono manifestati sfruttamento lavorativo nell'ambito dei cicli produttivi, e qui il Tribunale di Milano verifica che queste reali condizioni lavorative adottate nelle aziende appaltatrici vengono poi anche ribaltate nei confronti della filiera e quindi con elementi di valutazione della prova in ordine al delitto di caporalato. Questo mi sembra un problema che non è sempre stato valorizzato, perché qui abbiamo avuto vari casi, Armani, Loro Piana, Dior, Alviero Martini. Quindi l'approccio del Tribunale di Milano è stato quello di ritenere responsabili dello sfruttamento non solamente le società appaltatrici, ma anche i marchi committenti, in ragione dei mancati controlli sulla loro filiera. Quindi, se vogliamo trarre qualche conclusione, perché qui poi si è parlato anche di sviluppi legislativi, a parte quelli che venivano ricordati dal Presidente sabato in un contesto, diciamo, di interrelazione anche fra più corti internazionali, perché la parte finale del suo intervento ci ha ricordato come anche in altri, diciamo, in altre alte corti si siano posti questi problemi, diciamo, ma soprattutto può emergere un quadro normativo che non è solamente in divenire, come potrebbe essere quello delle direttive sulle due diligence nell'Unione Europea, ma soprattutto anche già alcuni elementi di diritto positivo che si sono consolidati non solamente per uno schema legislativo che è già stato costruito, ma soprattutto con l'applicazione che ne può fare la giurisprudenza, non solamente la giurisprudenza del diritto del lavoro, ma anche la giurisprudenza penale. Grazie.
Va bene, grazie professor Santoni. Thanks everyone. See you soon. In November in Tilburg. We're waiting for you.